Good morning. Welcome back to the second part of this third day meeting after the coordination session that we held with IESB earlier this morning at IFAC offices. I'm not going to say much about that because the board attended, part of the staff as well, and the others had the opportunity to observe online. So you have seen what happened there, and what happened is that apparently, and so far, I think that we can be confident and happy that we managed to reach agreements on apparently all the topics. So that everyone is happy with the coordination on both sides, but also mostly as in terms of having delivered or being able to deliver a product which is consistent, understandable, user-friendly, and etc. So I think it was a very successful meeting. Ken and really explained very well and very clearly the process, the thought process, and the reasons why we had to make these changes and why this is important. So all well, we are now best positioned that we were 2 hours ago to the end result of this exercise. So thank you to all of those who were involved in this over the last months and over this week. It was a very difficult exercise, but this is our housekeeping matters. What matters for the public interest is the result that we are able to deliver. Thank you very much. I think that we really should be proud of ourselves as a board and team about what we managed to achieve in such a difficult and tight time frame. Well, this. Not this. So we need to move to the next topic in the agenda, and our next topic is for the the workstream 1 to drive us to through the proposals and start a full review of what we have agreed, asking for comments from the board members. So Mark, Sylvia, I don't know who is going to start. Thank you very much in advance, and the floor is yours.
So we still have a couple of topics to discuss that we haven't presented so far, namely the provisions from the ED that address the independence matters when the firm performs both the audit and the sustainability assurance engagement, and that included the fees and the long association. So regarding the fees, so regarding the provisions or the proposal on the fees, when the fees, the firm receives fees for both the audit and sustainability assurance, we received quite a few comments, and there were generally the views, or I think there was mixed views about the proposals, and there were some views that the fees for the mandatory sustainability assurance shouldn't be disclosed and treated as fees for non-audit services. Also, there were some concerns that the disclosure of the sustainability, that the fees for the sustainability assurance and the audit is not clear as it was currently presented in the ED. And we received comments regarding the proposed approach for the proportion of the fees. There were comparisons between our proposals and the CSRD, and there were some comments that maybe we should consider further aligning our proposal regarding the proportion of the fees to the European Union's position in the CSRD directive. Some respondents raised that as the proposal on the proportion of the fees might have unintended consequences, and they believe that it's not necessarily in line with the objective of the IESBA that's really promoting the integrated reporting. So the task force went through these comments and discussed that in details. And regarding the comments on the fee disclosure, where we have landed that we believe that it's not necessary to provide or to add changes to the provisions on the fee disclosure that is in part 5,000, in part 5 in section 5,410, because one of the key objective of what's the key argument that the task force considered, that the national laws and regulations still require the clients and the firms to disclosure the fees for the audit of the financial statements separately. So the one of the key objective of the fees project as well, of IESBA fees project as well, to have transparency around that information. So solely on the fees for the audit of the financial statement and we believe this is an important transparency requirement and the safeguard around the auditor's independence as well. So we don't believe that it would be necessary to, so to say, to merge the disclosure of the fees. We believe that it's important to keep it separately. And I also would like to note that the disclosure or the provisions on the fee disclosure in the code is really principle based. So our main objective is to get these information on the audit fees and other fees, but there are no specific requirements on the breakdown on the further fees. So how the client or the firm should disclose the fees for these non-audit services, and also how to achieve this disclosure is also principle based. So we believe that really provides a flexibility for the firms to best operationalize these disclosures when the firm receives fees for audit and sustainability assurance engagements as well. So there is no change to these provisions. Regarding the proportion of the fees, as I mentioned, that there is quite a lot of comparison to the CSRD proposals that set out 70% fee cap, and they state that the fees for the sustainability assurance engagement shouldn't be considered for this 70%. I think the comparison with the CSRD, it's a bit tricky because what we propose regarding the proportion of the fees, it was simply a guidance. And we set out for the firms that if there is a large proportion of fees for sustainability assurance engagement to the audit fees, they should apply the conceptual framework. So there were no requirements, no fee cap. It was simply the application of the conceptual framework. So the comparison to this 70% fee cap is I don't believe it's an appropriate comparison, because our objectives and the whole basis of the two proposals were different. Nevertheless, we heard the views and the comments from stakeholders, and we proposed some changes to our guidance regarding the proportion of the fees. And as you can see on the screen, we introduced a new application material that would acknowledge that when we are considering the proportion of the fees from the same client, we are saying that where a firm or a network firm provides a sustainability assurance engagement mandated by lower regulation to the audit client, the fee for that engagement doesn't impact the level of the threats created by the proportion of the fees. So the computation or the comparison of the relative proportion of the fees is considering the fees, the mandated sustainability assurance engagement and the audit fees to other fees. So that's the proposal where we have landed regarding the proportion of the fees. And yeah, and I think I will just pause here and collect the comments regarding the fee disclosure and also this new proposal on the proportion of the fees that I think I will put back on the screen. So any comments?
Thank you very much, Sylvia. I think that there are still, if anyone has doubts, the presentation again is on the website in the documents list at the bottom of the list. Thank you very much, Sylvia. Sadia, please.
My comment is actually on the slide that we're on. And I think that we must acknowledge that even though it's application material, I think it's an important clarification we've provided. So I'm really happy and supportive of that clarification and it's clear that the interpretation wouldn't include things that are mandated by law. Okay.
Thank you, Sadia. I think this is a message for myself, as far as I heard yesterday as well. But I'd recall you speak loud, because it's not easy for the people in the room to hear, and it seems that myself have not been speaking enough loud. So apologies for that.
Thank you. So can you clarify? It says where the sustainability assurance is mandated by law or regulation. Is it mandated that they get an assurance engagement, or that the audit firm is the one that does the engagement?
Thank you very much for the question. Yeah, it's mandated that so the sustainability assurance engagement is mandated, irrespective whether if it's performed by the audit firm or anybody else.
Well, okay, because there are audits of financial statements that are mandated by law or regulation, and that didn't come into play, which maybe it should. I mean, my views on proportionate fees are well known, but I'm just trying to sort that through. So anyway, you answered my question. I just need to think about that some more. Thank you.
Thank you, Andy and Sylvia. Christelle, please.
Yes, this comment was sent to the work stream before the meeting, but it is about that mention about mandated by law or regulation. It is a useful addition, but a limited one, meaning that we address a situation where the Part 5 and independence provisions are applied. And to us, the point of law or regulation has nothing to do with it. If independence provisions and ethic provision from Part 5 are applied, why should the fees issued through that way be treated differently if they are required by law or not required by law? It was the trigger seems to us more in the fact that we apply all ethic and independence provision, and therefore we are comparable to an audit level of ethics and independence, and therefore the fees do not trigger a problem, of fee level and proportion. And so we propose that the trigger not be mandated by law or regulation to an audit client, but performed in compliance with Part 5 ethics and independence provisions.
Sorry, Christelle, just so that you propose that we would consider engagement that are under the scope of the independent standards of Part 5, not the ethics and independence, because that would cover all sustainability.
Yeah.
Okay, just to. So, thank you.
Thank you, Christelle. Can we collect one more comment and then respond? Luigi, please.
Well, I also think that my opinion on this matter is very clear. I repeated it many times during the previous meeting, and I don't think that there is any issue for the same reason that Christelle was explaining. So we are setting the standard at the highest level, at the same level of the audit, and we are saying that sustainability assurance fee are non-audit fees, and therefore there could be risk for independent. Then you find a solution, but it is really a partial solution, and it is like it sounds like a compromise that is really not satisfactory at all, because it doesn't solve the matter. Let's say if we are applying the same rules and the same independent standard as we are applying in the audit, what is the issue? And it is not linked to the fact that there is a law and regulation. It is linked to the fact that we are, let's say, the practitioner is required to be independent, as it is when performing the audit. So what is the issue? I really, there is no issue. And we are building here a very strange approach, which is clear. I really struggle to understand. Then I find the outcome and I said, well, instead of nothing, well, this may be a compromise, but really it is a compromise, not really satisfactory under the perspective of the general rules we are like to implement.
Mark, do you want to respond now? We still have Rich and Andy for the time being, but if you want to respond, we can ask.
I would come back on that one. I do acknowledge Luigi's point that it's a slightly sort of strange construction, but it is a slightly strange construction because at the moment we've got a range of different situations where engagements are either required by law or not required by law, and therefore there is a recognition. And I think the task force has talked about this across a lot of jurisdictions where something mandated by law or regulation, there is a need to accommodate that. But I would say, like, this is all crafted within the context of application guidance. So it's not actually setting requirements. It's actually saying we have a framework at the moment within the code that applies in the context of audit fees and the relativity of other fees for non-audit services. That's very straightforward to people who are professional accountants and working in the sector, but for people who aren't, and therefore who are coming to this, there is a need for some application guidance to help with that. So it does need to be seen in the context that we're not putting additional requirements on. We're actually trying to explain this so it can be used by people other than professional accountants and auditors.
But are we envisaging that the audit should be performed also by non-PA? So this is just for the PA.
Right. This is just for PA.
This is for the provider of the assurance for.
Those that are
PA.
performing audit,
But
and
If it's another
sustainability.
PA, but who is not the.
yeah, but the thing is,
provider of-
this is we're talking about this in the context of where the auditor is providing the sustainability services. Nevertheless, we do need to understand we do need to be able to explain how this applies, because we are setting this up as something that can be used by the code intended for a wider audience, and that's why this is explained in application material.
Thank you, Mark. Rich, please.
Yes, thank you. So I have a number of points. I am generally supportive of what we've done here, but I have some practical questions and also maybe a suggestion for basis for conclusion. So if I'm reading this correctly, and the firm is the auditor and also the sustainability assurance provider, for purposes of assessing the threats of non-audit services, the audit firm leaves out of both the numerator and the denominator the fees related to the sustainability assurance engagement, or do they just leave it out of the numerator, which is the is where you would put non-audit services and add those up? That's kind of my first question. My second question, and maybe this is the basis for conclusion, if I understand the theory here, we're saying because the sustainability assurance engagement is an opinion level engagement, reasonable assurance, then that is the equivalent to the reasonable assurance provided in the audit, and therefore we should not consider it a non-assurance service. That may need to be explained in the basis of conclusion, because there are other assurance services that are required by law and regulation that at least require limited assurance, or and we're not exempting those here from the calculation. And I think we need to justify why we're exempting the one but not the others. And again, that can be done in the basis for conclusion. And then I presume that when I turn around and as the sustainability assurance provider in part 5 and also the auditor, but when I make the assessment in part 5, I also either don't include the audit fees in both the numerator and denominator, or do I only leave them out of the numerator and I include them in the denominator? It's more of a practical of how do we do the calculations that I'm trying to get at, but those would be my 3 points. Thank you.
Thank you very much, Rich. Andy, please.
Yeah, thank you. And thank you for letting me come back. And yeah, I had similar mathematical things on mine as well to understand. But I guess I do want to be clear. I don't agree with this answer. I don't agree with the only scoping out the mandated by law regulation, because audits are sometimes you have one audit mandated, sometimes you have the other, sometimes you have both, but whether you have them at the same firm. And I'm trying to do a tightrope walk between my just general objection to, well, I believe that the absolute level of fees creates a self-interest. That proportion of fees I've never been on board with. But I think the thing that I'm seeing is that if I'm independent, and this is for the PA section. So, I mean, I think this is really directed at the PA and PA conversant folks. If I'm the PA and I'm signing the audit report and I'm not independent because of a defect in the proportion of fees, or if I am independent because I don't have the defect in proportion of fees, I'm not independent. And then I do another assurance level engagement. And yet and if it's not mandated by law or regulation, there may be a pathway that somehow the practitioner is not independent because of a defect in that proportion. And that I just don't see that. I see that I'm either independent from the management making these assertions or I'm not. And so all of the assurance work that I'm doing at this audit level assurance, I just fail to see how that wouldn't be grouped together intellectually for my independence of the company. But again, I have an issue with proportion of fees, so take what I say with a grain of salt. So I do appreciate some relief with regard to the mandated, but I think the answer is that all audits should be together. I hear it's application guidance, but gosh, this is some pretty heavy lifting that application guidance is doing in terms of setting actual mathematical calculations for the practitioner to do. And I realize it's listed as a statement of fact and not a shall answer in there. But boy, I'm having a hard time understanding how this actually doesn't set a course of action equivalent to a requirement level a statement in our code. Thank you.
So actually, I think probably Richie's comments take us back to where we were in some earlier discussions that the task force had, where actually we'd illustrated this by way of a table, and actually either in the basis for conclusions or somehow it would probably be much easier to explain it by way of a table than it would by further explanation in terms of how it works. I appreciate the tightrope comment, and I do feel we're on a bit of a tightrope ourselves. But one of the things we're very mindful of is the fact that we're in a position where law and regulation are almost playing a bit of catch up. So, the basis for the audit and the audit fee is very clearly scoped in law in jurisdictions. In a number of jurisdictions, you have certain non-audit services or additional assurance services that may be required by law or regulation, and where that's the case, you generally exclude those fees from an impact on the independence or otherwise of the provider of those services. Where we are with sustainability assurance is that it's in a bit of a no man's land at the moment. In the EU, there is a clear legal structure. In a number of other jurisdictions, that's yet to be put in place. So I think that the principle that we're trying to say is where there is the provision of a statutory service, then there needs to be the relief that we're trying to set out in 4.10.11a2a. But there is a recognition that it will take some time for the legal and regulatory framework in all jurisdictions to catch up to that. And one of the things that we were very mindful of is we didn't want a situation where the code is almost sort of seen as trying to overrule what law requires in a particular jurisdiction. Do you want to come in on that, Channa? Because we've discussed it many times.
Yeah, so I mean, just from an Australian perspective, the laws have just been passed that the external auditor do the sustainability assurance engagement. So that's a example. And I mean, there's the possibility that in the early years, the sustainability fee could be quite high as well. So this mechanism allows, for that to be not taken into account when you're looking at the non-audit fee proportion. I think I think that table is useful, as Mark said, and maybe that can go into the basis for conclusions. And I also take the point that I wonder whether, there could be other audits that's also required by law or regulation for the external auditor to be performed. And generally, like when you look at even the 70% calculation, those are, if the auditor has to do it, those are excluded, right? From the calculation.
So on a quantum sort of basis, perhaps an example that might sort of be comparable to a sustainability type engagement is that from a UK perspective, where you have, say, a class 1 transaction, you have a number of public reports that are required, and those are required by law or regulation. So they never touch, for instance, on the non-audit services fee cap, even though they may be a multiple of the audit fee. And it's a recognition of the fact that certain things are mandated by law or regulation, and therefore we should reflect the fact that where there is that requirement, although obviously in accordance with the conceptual framework, the professional accountant would always be aware of any impact on their independence and safeguard it, we should reflect that in the application material, particularly because we're seeing more of this sort of type of example. So that's the reason it's in there, but we can certainly take that away and have a further discussion.
Thank you, Mark. Christelle.
Yes. If I take the example of France, it is not so easy. If the regulation is not clear about how you deal with those type of new assurance fees, you have to go to the regulator or to ask for a waiver, because otherwise, in a legal way, they still see audit and non-audit. Okay, so it's not a given. You also might have some jurisdictions where there is no law or regulation in the short term. So that means that even if you apply the highest ethics and independence, and more about independence rules of the IESBA, you still are not allowed to cope with the objective, which is relative proportion of fee for you added mandated, but why not mandated but done under this framework should not be addressed also. I think if it's application material, if you go to substance, if you go to principle, if you have the same independence rule, why shouldn't you address this in a generic way? And I understand that maybe in some guidance, etc., to help regulator understand that there might be good to be settled in a assertive way in their regulations. This is the principle. If things are done with the same independence, why should it hurt through the proportion of fees? So I'm still not convinced that the law and regulation is bringing something additional to a general principle there.
Thank you, Christelle. Rania, please.
So my first comment basically is like picking up on what Andy said. Honestly, I think that when we're saying that if the sustainability assurance engagement is not mandated, then there is an issue of independence. I think that, and also what Christelle just said, I think that it has a trickle-down effect on the perception of independence, where the assurance engagement is mandated. So I think, I think this was the case with consultancy. It first started out for publicly held or listed companies, but then that trickled down to privately held companies because of the perception of independence. So I think we have to think clearly about this. That's one. Second, I mean, originally, if you remember, I was also against this issue of, you know, the proportion of fees, but very frankly, listening to, I mean, to what you've said, I mean, I see your point. I think you make a compelling point for having it in there, but I also still see the counter argument. However, my concern is basically for the financial statement audit profession. So the way I see it, and that's really a question I'm putting to the board. So today, we're treating sustainability assurance like basically a financial statement audit. Okay, we're asking auditors or PAs to build the capacity. It's going to add a major toll on PAs in order to build the capacity, a lot of cost, training, so on and so forth. And then, and the expectation, as basically what Chan has just said, that sustainability assurance fees will be much higher. And then you're telling them you have to consider the proportion of fees. I think if we put all these factors together, I think that PAs will naturally gravitate towards sustainability assurance engagements, because I think if you do the math, it will be more lucrative for them. At the end of the day, we have to keep in mind that, you know, the audit profession is a profit-seeking profession. And I mean, you have to strike that balance. So my question is, so recognizing full well that there are arguments for and against, my question is, do we anticipate any long-term effects on the investments to be made in, you know, the financial statement, audit quality, and, you know, keeping the profession up to par and up to expectations? Because I think if you look at all the responsibility and all the burden that's being added on PAs, and now you are bringing in the non-PAs into the assurance space, there's a lot of competition and a lot of pressure. I think if we think about it, I'm not sure how fair that is. I mean, the public interest comes before anything. But at the end of the day, I believe we also have to be fair to the PA profession to make sure that we do not add unduly stringent requirements, because that might have long-term repercussions or unintended consequences. Thank you.
I think, you know, that you make a really good point, but I would remind the board to go back to the position that the board agreed regarding the scope of Part 5. So we agreed that the scope of Part 5 was that it applied to a sustainability engagement where a practitioner expresses an opinion in accordance with a general purpose financial reporting framework and required to be provided in accordance with law or regulation, or publicly disclosed to support decision making by investors or other users. So given that we've got within the scope a recognition of the importance of a sustainability engagement being mandated by law or regulation, I do feel it's appropriate that we recognise the weighting of that law or regulation when considering any independence issues related to fees. So I absolutely, you know, recognise your point about, is this an unreasonable burden? Is it going to impact on what we're asking the sector to do? Equally, you know, it does align with where we've got to in terms of the agreed scope, and the fact that law and regulation has a significant determining factor over whether or not you apply Part 5 when you're carrying out your engagement. But I say that the task force can discuss it, but that would be, I think, the most sort of important determinant in that fee question.
Thank you, Mark. Sadia, please.
I just wanted to mention that there is a post-implementation review on these sections that's upcoming. So a post-implementation review on fees. And audit firms are issuing audit reports and sustainability assurance reports. So the way it currently stands there, it actually is being applied. So it will be important to see how that has been applied and what kind of challenges they're facing. And it's kind of nice timing because it comes out just before this becomes effective. So whichever direction we follow, it's important to note that in the fees post-implementation review, we might be able to put this here in as early understanding of how this provision is working.
Thank you, Sadia. Paul, please.
Thanks so much. Maybe slightly a lateral question that where we're making first and foremost, acknowledging that the provision of sustainability assurance work will call for substantial capacity building within PA firms to do it effectively. The minute then you say that the proportion of fees importance is different when it's mandated or not mandated, could that result in a situation where you have effectively those doing the most capacity building only working in mandated spaces because the costs will not be held against them, and then causing almost non-mandated spaces are forced to work with potential PAs who are not spending as much or as competent because they don't carry that same, they're not afraid of the proportion of fees risk issue. Sorry, I'm going a bit laterally, just trying to understand what's the implication of this differentiation on crowding in or crowding out the right competency and depth from the non-mandated space, because it's still very substantial. Thank you.
Okay, thank you, Paul. Chana, please.
When you go through the fees section, the key requirement is in R4 10.6, which says subject to paragraph R4 10.7, and 4.10.7 is about cost savings. A firm shall not allow the audit fee to be influenced by the provision of services other than an audit to an audit client by the firm or network firm. So that is the key requirement. The rest is all guidance. So the key requirement in the fees section is subject to paragraph R4 10.7, and 4.10.7 is about cost savings. So it has no implication for the issue we are discussing. A firm shall not allow the audit fee to be influenced by the provision of services other than an audit to an audit client by the firm or network firm. So that is the key requirement in the fees section.
Maybe I'll jump in here, John.
Yeah.
It's a slightly different issue because the requirement you're quoting is more addressing the level of the audit fee as opposed to the proportion of the fee here, which we are discussing.
But then, Ken, on the proportion of fees other than the audit, it's all guidance.
It is all guidance, but clearly the expectations are set in the guidance as well. Because of the application of the conceptual framework.
Yeah.
And firms have to apply the conceptual framework in with it.
So what I'm sort of coming to is that it's sort of at the end, it's a judgment. And what we are saying is when it's mandated by law or regulation, that judgment is taken out of you because that country's jurisdiction has decided that the external auditor shall do this work.
may do.
I will come back, but and I see there are board members who would like to.
Yeah.
So I think the next one was Vanya.
Thank you. I'm hearing the discussion here, but I'm thinking on the other way round. I'm analyzing, despite the fact that one of the comments that Sylvia made was that it was not exactly an integrated reporting. If you think on IFRS Foundation, as IFRS 1 is the framework for integrated reporting, all sustainability reporting prepared under IFRS Foundation standards will be an integrated reporting. It's unavoidable. And then the main aspect of integrated reporting is to use the financial statements as a link to anchor the reliability of the narrative and qualitative information of sustainability reporting. And so I have to submit the sustainability reporting to assurance now because it is mandated. I think this kind of situation as a protection for the fact that when you have the same auditor looking at sustainability and the financial, it is more interesting for the public interest because this auditor already knows deeply the financial statements, so they would have better conditions to track the information of sustainability for the financials. And so I see this kind of aspect as a protection. Do not avoid using the auditor due to fee to get a cheaper one, a cheaper service, because we want the same level of quality in the assurance for sustainability as we want for the financial aspects. That's how I was reading this.
And just to come back on that, absolutely great point. But for instance, if I look at it from a UK perspective at the moment, we do not have any mandated assurance over sustainability reporting because we're waiting for law to be introduced to consider whether or not to allow it. At the moment, a lot of companies are commissioning either their external auditor or someone else to provide assurance over their sustainability information. But it is not a requirement of law or regulation, and we have to have that differentiator because there is a period in which jurisdictions will catch up. And as you say, Vanya, you know, where you have, as you will in Brazil, a package of integrated reporting that is assured, then you know that is the package over which you are asking your providers to do this. But it does need to reflect the fact that not all jurisdictions are in the same place, and we can't make an assumption on the back of one because it won't necessarily apply in all situations. Like one of the things that I might hope is that over time the legal and the regulatory framework catch up.
Yeah.
And you know, people recognize that sustainability assurance to the same level as the audit of financial statements is something that is desirable and should be required.
Yeah.
And therefore it takes away that sort of fee question because you've got a statutory backing for it.
Thank you. Rich, please.
Yeah, I feel strongly that to require the auditor to consider a sustainability assurance engagement as a non-audit service when you're issuing a reasonable assurance opinion is just wrong. And so I support what we're trying to do here. I think the question is whether it should be expanded further, but I'm a little confused. I mean, it says mandated by law or regulation. Well, so far, there are lots of laws and regulations that are going to mandate this, even though they're from a country you aren't domiciled in, but you do business in, right? So we're seeing that in the EU. We'll see that in the state of California laws. I'm sure we're going to see that in statutes coming out elsewhere. And so I think I think it's very important that since the reasonable assurance opinion is the equivalent of an audit, it's only over sustainability, that should never be considered a non-audit service. And I think that's what you were trying to do with this. And so that's why I support what you've done here. Thanks.
Thank you. Luigi, please.
Just to clarify a point, while laws and regulation are progressing in a different way, I think that at the end, the philosophical question here is whether this is an audit or not. If this is an audit and we are applying almost all, probably more than the rules and requirements and application material that are now in the extant code, if it is, I really struggle to understand where is the issue. Because the world is changing, but we still are believing that while applying the same rule, this is not an audit. So I do not understand why we are not able to keep the pace with the world, which is changing. And therefore, if then I am forced to accept no solution or this solution, of course, as I mentioned before, let's say, instead of nothing, this is something. But it is not the right solution because we are not aligning our text and our new code to the reality which is changing, and it has changed a lot in many jurisdictions. So I think we are still behind what we need to be, and we are not recognizing that the entire effort that we did and we are doing here is because we are treating this sustainability assurance as an audit. And we still believe that it is a non-audit service, which is, well, I'm not able to understand, frankly, and it is up to me. Sorry for that.
And you don't like it to sound over semantics, but we've never said it's an audit. It's equivalent to an audit. And I think that's an important thing because in many jurisdictions, audit is a defined term and audit is a regulated activity in the public interest. In many jurisdictions at the moment, there is no regulation of sustainability reporting or sustainability assurance. That's still to come. So what we've done is we've tried to be forward-looking and create a regime that is equivalent to an audit because we recognise that it's in the public interest to have that sort of, similar level of assurance in the public interest. But at the moment, it is not an audit, it's an assurance engagement over sustainability. That may change over time, and of course we can then reflect it, but we'll look to see whether there's a way in which we can sort of better reflect it. But I think we are working within a very variable mix of legal and regulatory requirements across different jurisdictions.
Thank you, Mark. And if I may, I know that there are still some board members wanting to speak, but if I may just add something to the discussion in terms of a request or a challenge, is that we go back to the reasons why this framework exists for financial statements. And I'm not trying to say anything. I'm just trying to say that more than words, we should think about how much these different situations, if it's required by law, if it's not required by law, and etc., threatens somehow the quality of the financial statements, which is the underlying reason of the original framework. If it does affect, if it does not affect, how much is it different, and etc., and see if the solutions that each one of you are supporting fit into this substantial concern, which is how much can or not a provider of sustainability, an auditor of financial statements become hostage of that client because he or she is providing a huge amount of or making a huge amount of money by providing sustainability assurance. I think this is the question, and this should be the criteria driving our decisions. And I'm not saying at all that this decision for the time being should be one or not, but I think that we should drive our approach according to this perspective or criteria. Christelle?
Yes. On the point of huge fees, if you have a merger, you can double your fees on a client because you were not the auditor of one of the merging companies. So the absolute value is depending on a lot of things and doesn't, it is necessary, well, at least I suppose it is necessary. You have a counterpart with the client to negotiate the right level, and it is necessary to have the good quality. My point here is, if part 5 is already stating that it is only if required by law that you are in the independence chapter of part 5, if here you reference part 5 instead of law and regulation, you address the question of different organizations of group, because the legislation might ask to the head of group to publish an assurance on sustainability, but not at all levels of the organizations, etc. And having these kind of thresholds or condition, you can make it difficult, depending on the legislation in the different countries, to afford the mission for the head of the group. So I think we should go back to the principle. I understand that it has to be the same level of independence. We have stated the same level of independence within the chapter 5 independence rules. If this is applied, I think principle ruled. If you apply part 5, ethics and independence, or independence, you are in the situation where you want to be, because it is supposed for independence to be mandated, but there are also all other conditions. Yeah, you have it all in one, if I understand well.
Thank you, Christelle. Sorry, Janine, I know that you have been waiting for long. Do you want to wait for everybody to speak
Yeah,
up?
that's fine.
Okay, just did not want
I
to
could
keep
also
you on
make
hold.
a few comments conceptually, but
As
whatever
you
you
prefer.
prefer.
So maybe listen to you may have other things to say. Okay, Paul.
Thanks. Maybe just clarification. I think, Mark, you're very clear that we are certain that sustainable assurance is equivalent.
Paul, can I, sorry, ask
Yeah. Sorry.
a bit louder?
If we are starting from the point of recognizing that sustainability assurance is equivalent to audit, what's the risk that arises where we have not, basically you have a non-equivalent standards applying to an equivalent service, depending on whether it is regulated or not regulated. And that's a kind of mandate progression issue. Isn't there a risk in that? If we've said, yes, they're equivalent, so why set different requirements? Simply because based on whether a country has progressed to mandating or not. No, the service is the same. Thanks.
Thanks, Paul. Can we collect another comment? Angie, please.
Yeah, no, thanks again for letting me come back. And I just want to make sure I'm just dealing with part 4A right now and its interaction. And when part 4A was amended, we didn't have part 5 and we didn't have that. And I do appreciate that part 4A does already have application guidance as part of what you consider the level of threat, as whether it's required by law and regulation. So be it, I see that. But I think the difference is we didn't have part 5 and we didn't have this other level of service where independence would be required. And so for me, it's more about independence being required, and intellectually, if I'm considered independent because I've passed a proportional test for my audit, whether or not the assurance engagement is required by law or regulation or not, in this case, I don't think means I could be somehow independent here, but not independent there. I'm either independent or I'm not. That's how I'm seeing it. And I know that we did not take into account a level of service like this because it wasn't yet really invented yet when we came up with it. So I don't believe I'm being inconsistent with where I'm standing with, well, I appreciate the application guidance only applied to the required by law regulation. I think for sustainability assurance, I see this independence as somewhat schizophrenic if we don't permit them all to be bundled together. So I hope I have nothing more to say. Thank you, Chair.
Thank you. I think it illustrates, and your comment in particular, Paul, illustrates the difference between recognizing, from the outset that the level of public interest in sustainability reporting meant that we should treat it as equivalent to an audit of financial statements. But it does reflect the fact that the legal and regulatory framework that underpin that is a developing one, and therefore we shouldn't use the code to make good the absence of law or regulation. So I think that's absolutely the case. In principle, Andy, I agree with what you say, but I work in a slightly odd environment where, for instance, you might be auditing a company that's a public interest entity, and if you provide non-audit services that are worth 60%, 65% of the fee cap, you're independent. But if you provide 75% of the fee cap, you're no longer independent. So there are some arbitrary considerations that exist through differing legal and regulatory requirements. And I just don't want to be sort of cutting across and saying stuff that tries to sort of fit into to avoid. But we will, we've got another meeting that we can discuss through. So very happy to take all of the points that the board has made and to see if we can make something that's clearer or, works more effectively. But I think I'm just rather painfully aware of the fact that this is both something where your principle of I'm independent here, so I must be independent there is a fair one, but equally you might be wrong. I'm just mindful of the fact that we need to do long association as well. So we need to sort of leave some time to do that.
Okay, Mark, thank you. We will still have Christelle, Paul, and then Janine and Ken. Christelle, please.
Yeah. Very quick, promised my last. Is there, by any odd pass, is it possible to have a situation where you have a rule or a law or regulation asking for assurance, but not integrating our Part 5 developments? Therefore, this formulation would allow for looking at it's okay, even despite the fact that the principles of independence and ethics, etc., have not been applied the same way. Is there a path for that, or I missed something?
So in theory, that could happen if you've got a requirement to report under a special purpose framework.
Yeah.
This applies in the context of a general purpose reporting framework, which is, all of the main frameworks that we're aware that exist. There could always be a particular, specific sect that a jurisdiction might say, we want this. But that would be reporting under a special purpose framework, so therefore wouldn't fall within the scope of Part 5. So
are we okay that it should be treated the same way on a proportion of fees?
Well, that's what we agreed from the outset in terms of the scope. So that's where we get to.
Well, maybe that releases some concerns. Paul, please.
Thanks. I think I completely hear the point that we can't imagine the code can be used to fix anomalies in law and bring alignment across laws. But is the differential treatment being urged through the code intended to also create some kind of stakeholder intervention and responsiveness to push governments for more alignment in law? Like you will not be treated fairly until you get your people to fix your law. I'm just wondering yeah.
No, not at all. And God, I can remember at the start of this, I was slightly appalled that we're going to use the code for sustainability. So trying to use it as a token to move governments is perhaps a. But the thing is, what we're trying to do is leverage the principle in the code as it applies at the moment and try and be consistent. So it's not that we're seeking to punish or drive change or whatever. It's that the principle that we followed in developing the whole Part 5 is that we want it because we recognise that for the scope that we've identified, this is sustainability information that is used for decision making, and therefore it should be as trustworthy and reliable, and it should reflect the public interest just as much as an audited set of financial statements do. So therefore, and we're also aware that in doing that, a number of jurisdictions are moving down a route where they say, well, sustainability is equivalent to audit, so therefore it should be the same. You shouldn't have a lower level or a different level. So it's not that we're saying you need to hurry up and change the framework, because the code has always recognised that jurisdictions are the ones who own the legal and regulatory framework, and it's up to them, as to what they do. We develop the code in a way that can be applicable in any jurisdiction, wherever it is on that journey in terms of developing a law, its own legal or regulatory framework. So it's certainly nothing more than that. But that's the sort of approach that we've followed.
Just come back on that where we're saying that your proportion of fee assessment will apply or not apply based on where it's mandated or not. It seems to go very contrary to what you just said, that we're saying this is an equivalent service that should be that should be subject to a consistent standard and treatment across all spaces. But for the doer of the service, it will harm you if your country has not moved forward to mandate, or it will be beneficial to you if it has. That's what I'm not quite understanding.
I don't think it would be beneficial or harmful to you. It's just whether or not the fee that is charged for the sustainability assurance engagement is one that is required by law, so therefore has no consideration in terms of its impact on independence, or whether it is, or whether it's not required by law or regulation, in which case you need to consider whether there's a threat, and you need to, if appropriate, safeguard that. But it's not a requirement, it's application material to explain how that works.
Okay, thank you, Paul and Mark. Janine,
Okay.
I'll speak.
Thank you. Yes, I like to make a couple of remarks in relation to this. I also like to start actually with referring to our public interest issues that we published, which also one of them is also in relation to the fee discussion. And in there it says, let me look here, sustainability assurance fees should be treated the same way as audit, as assurance is compatible for independence purposes, as the sustainability assurance is compatible for independence purposes. And it should also be like that in the code. That is the PIOB's view. So Mark was saying sustainability assurance is equivalent to audit. For that purpose, yes. That's also the way the PIOB discussed this. Some other things that I like to make comments about is around the difference between non-audit versus non-assurance, because I think services, that is also here the part of the complexity. But I like to add one perspective, the perspective of a wide range of users of the auditor assurance reports. and the difference between mandatory or voluntary, also from that perspective. And to say something like this is application material, personally, that's another thing. I struggle to see how the proposed application material wording can address a proportion of fee requirement that already exists in the code. In terms of enforceability, I think that's very, very difficult. Only if there is an overarching requirement, very high level requirement, and then with such a specific things in application material. So for me, audit is an assurance engagement that provides reasonable assurance, and sustainability assurance services are other assurance engagements as per the IESAs, which provide either limited or reasonable assurance. And when you give assurance, it is being used and relied upon by users, and other assurance services is also often for a wide range of users and as such in the public interest. So for sustainability assurance, that is why the same level of independence requirements should apply likewise to an audit. That's conceptually the way I look at it. And conceptually, I think other assurance services not automatically, because of this, pose a threat to the independence of the auditor. And the audit and assurance reports could be used by the same wide range of users. So both mandatory and voluntary audit or sustainability assurance services provide assurance, either limited or reasonable, to a wide range of users. Also, there's also overlap with which users. And so I also fail to see why voluntary sustainability assurance work should not have the same level of, or should be treated differently in this discussion, because it's used. It's same with audit. It can be voluntary audit, but users, say a bank provides a loan on it or whatever, even though it's voluntary. I don't see with a conceptual thing like independence that you can make a difference in whether it's required by law or not. And we also say that the IESAs apply when it's a voluntary audit. And I think we also here say that, or the sustainability assurance standards could apply even if it's voluntary. There are not laws and regulations yet requiring this specifically in jurisdictions in the beginning, but even maybe 5 years from now, not in all kind of jurisdictions. So I think what you put in here, it should apply for many years. And it needs to be conceptually sound. Let me put it like that. So these were my comments that I'd like to share with you. Thank you.
Thank you, Janine. But just for the sake of my clarity, so I understand that your approach is that both mandatory sustainability assurance and non-mandatory sustainability assurance should be treated the same way.
Yes.
For this purpose. But does that mean that your or the PIOB understanding is that we should keep the approach which is set up for financial statements in Part 4A, or that both of them should be treated as not posing any self-threat interest self-interest threat that might affect the financials, the audit of financial statements? It's because that was not. I understood that you want them to be treated equally. I just did not understand what would it mean in terms of the approach.
Well, I see it conceptually, and this is not in full debated within the PIB, but conceptually, I see an sustainability assurance service not as a different thing as an audit. Also, because now we start with limited assurance, but can be reasonable. It's the same, but other thing that is being assured, other information, but it's the same concept. So I don't see here the issue with proportionate fee at all.
Okay.
That is
sorry, just I think it needed to be clear.
Yeah.
Ken, please.
Thank you, Chair. Really just reflecting on the discussions. First of all, just in terms of how the provision is articulated, I think if it is going to stay, it probably needs some further refinement because at the moment it is referring to a sustainability assurance engagement mandated by law or regulations. In other words, any type of sustainability assurance engagement, not only those we're talking about within the scope of the IAS in Part 5. And if that's the intent, the board needs to understand that. So that's one thing. The second thing is, I think Janine has mentioned, again, I'm not trying to take sides or whatever, but really what I want to make sure is that where the board lands, it lands in a position that is conceptually sound, and that's to Janice's point. And from what I'm hearing, I think there are a number of perspectives that are pointing to potential inconsistencies or sort of gaps in terms of how this provision would address the issue of proportion of fees. Just for example, to take one example, and we talk about jurisdictions perhaps progressing at different speeds in terms of legislating and mandating sustainability assurance engagements. Let's assume that if there is going to be a law or regulation that will mandate such an engagement, it will be for reasonable assurance engagements, or potentially limited, but let's say reasonable assurance engagements. And we might have two similar jurisdictions that are similar in the sense that they are intent on legislating and mandating for these engagements. But one jurisdiction has already gone ahead and enacted the appropriate laws and regulations, etc. And therefore, this provision will apply in that jurisdiction. But in the other jurisdiction, maybe they are 2 years behind in terms of their legal processes, etc. But they are very clear that they would like to mandate as well. And the consequence would be that because of the operation of this provision in the first jurisdiction, essentially there's no issue. You wouldn't consider the fees for that sustainability engagement as part of your assessment of threats relative to proportion of fees. But in the other one, because there isn't a requirement in our regulation, practitioners might still be carrying out the same types of sustainability engagements in the other jurisdiction. In that other jurisdiction, you would have to take into account those fees because, in effect, those engagements are on a voluntary basis. So that's just one example of what the board, I think, needs to weigh as to whether, because of the operation of this provision, we might end up with certain outcomes that may not be entirely consistent in terms of how the board is envisioning the principle to operate. And maybe there's a matter of, or maybe it's a question of identifying all those potential sort of gaps or inconsistencies, if you will, and making an assessment as to whether essentially on the balance, these provisions should stay as it is, or whether it should be removed and addressed, and essentially the board should address all sustainability assurance engagements, whether they're mandatory or voluntary, in the same way. The other observation I would just point out is that the way this provision, and now I'm just reading it, because we're putting the focus on sustainability assurance engagements mandated by law or regulation. There is a question as to whether this provision should be extended to all of the assurance engagements mandated by law or regulation, whether or not they're on sustainability information, and why only sustainability assurance engagement. So that's, again, we need to look at it in a kind of more holistic way and saying whether what we're addressing here really does justice to what is the issue.
So thank you very much for this very good discussion. Mark, I don't know if you want to say anything else, but I think that you have here the elements.
That's a really helpful steer on do we actually need either we need a consistency point on any engagement required by law or regulation, or do we say in respect of 4.10.11a2a that it is actually where a firm or network firm performs the sustainability assurance engagement, which falls within the scope of Part 5, which might also address that. I agree with what Janine said, absolutely, in principle, that a consistent approach should apply. But at the moment, when I go back home, someone carrying out a sustainability assurance engagement in the UK for fees purposes is just treated as a non-audit service because it counts towards the fee cap. And we have a situation where I think a number of entities may struggle to get their auditors to do assurance of their sustainability information because there isn't room in the fee cap to do it. So, there is that practical consideration, but that's a really helpful steer for us. And we'll look at those options in terms of either being clear on Part 5 or being clear on engagements required by law or regulation more broadly. But if I can take that and we'll discuss it, and I'll hand back to Sylvia to go through the little bit of long association.
Hopefully a bit less controversial. So yeah. So the next area of or next set of provisions that really aim to address any potential independence arising from the fact that the firm provides the audit services and the sustainability assurance services to the same client was the long association. And being in the ED, we set out that our intention is that we would treat the key audit partners and the key sustainability assurance leaders the same way. Therefore, if someone provided some services or served any of these positions, that would be treated as the same way for the perspective of the calculation of the partner rotation. So that was our proposal. And we received very few comments on these provisions, actually. There were only a few respondents who raised whether the partner rotation in the sustainability assurance context is necessary at all, and maybe we should better focusing on firm rotation, which we believe is not the appropriate approach because that's not we apply in the context of the audit either. There were some questions that how we should calculate the time on period if the engagement leader served in an engagement that wasn't under Part 5, but it was a Part 4B type of engagement, that how he or she should calculate the time on period and the 7-year rotation. And also there were some suggestions that we consider providing some transitional provisions. So for the situations when an individual served as a leader or participated in an engagement before these provisions come into effect. So the task force discussed this point, and as I mentioned, we believe that it is important to treat the partners and the leaders the same way for the audit and the sustainability assurance engagement. So we believe the partner rotation is necessary, and we suggest to retain it in the draft standard. However, we recognize that some guidance would be useful for instances where an individual participated in a sustainability engagement that is not under Part 5, and how that individual should calculate the 7 years. So we introduced a guidance, and we actually mirrored the approach that is currently applicable when the firm becomes a PI. And again, the provisions would kick in, and they need to consider the previous years as well. Similar to that approach, we believe that if the engagement becomes a Part 5 engagement, it doesn't mean that this individual shouldn't consider the previous year served with the client. However, we recognize that we should allow some latitude in that. So following the currently applicable guidance in the case of non-PIs becoming PIs, we say that the individual should consider the previous year served. However, if the individual already served more than 6 years, there is an exception for them. And in case those charged with governance concur, the individual can continue participating in the engagement for 2 more years. So that's the guidance we are providing when an engagement that wasn't a Part 5 engagement becoming a Part 5 engagement, and the more stringent requirements would apply. Regarding the questions on the transition provisions, we propose to apply the same approach when the provisions would come into effect. So if before this 2026 date, the individual participated in the engagement, we believe that the individual should consider the year spent on the engagement before the effective date as well. However, we are providing the same kind of exception that if those charged with governance concurs, that the individual can continue for 2 more years in that engagement. So really, we believe that really provides a consistent approach across these transitional kind of questions and how to count or calculate the 7 years rotation period. And what you can see on the screen is really these long guidance, these new, yes. So that's why I sorry? Yes, so I have it on the slides in case we need to talk about that. But really, I think that slides I provided before better summarizes that approach that we have.
It's not a single sentence.
Yes. So I would stop here and just collect some comments on the provisions related to the long association, and specifically on these new proposed guidance from these transitional situations. This one, the long one. Okay.
Thank you, Sylvia. Sonam, please.
I can understand. I understand, and I support of the new proposal. My point is, in terms of transition provision, the one is for me really difficult. I'm struggling to understand in which situation this provision is applied. So it may be described in the basis for conclusions. That's my point. And also here is a small thing. So do we need, in the second row, where the form will perform, do we need where? We haven't used where normally in the standard or in the requirements. So that's my small point. Thank you.
Right. Thank you, Sonam. Sadia.
So I have 2 questions. The first one is related to the Sonam question, and it's, is there a reason why we're not being direct and saying, if you were previously in Part 4B and now you're coming into this year? And I'm guessing it's because you want to be profession agnostic, because you might not have been within the IESBA code. Okay. And that's where the difficulty comes in that drafting in that first 3 paragraphs. But I thought that even if it's Part 4B and another one, it would be more direct. The other thing is on the transitional provisions. Usually long association transitional provisions are complicated because it comes with some maths and calculation. So usually we do have an example, for example, in the case of when the first one. So I would ask the task group just go back and look at how we usually draft them to be a little more helpful.
Thank you very much, Sadia. Christelle.
My difficulty was to try to imagine how it applied to a non-PA firm. Is it only the transitional provision that is applying, and do we have to think about what kind of assurance work they were doing before, or does it only concern, because this is in Part 5, so it addresses all types of practitioners, yes?
Yes.
So transitioning with audit is not the situation I want to address, but you're transitioning from other types of assurance, certification, or other type of relationship with the. Do we address it through that? And maybe one of the examples could be like that, to just put substance on what we want to avoid, because some organizations have very long association. For example, I know that in boat certification world, it is dozens and dozens of years, not only individual, but the relationships. So I think it's worth giving some meat on that interpretation or application. Thank you.
Thank you, Chriselle. I think you have a point there, because if we are wanting to treat both audit and sustainability assurance at the same level of independence, the impact of long associations should be probably considered on both sides. But of course, the task force will take that on board for consideration.
And that was our intention as well. So these would apply to non-PAs as well, not just PAs. But I recognize that it's a bit more difficult in the non-PA world because it's not clear where are they coming from. But that's something we will consider how we can be helpful.
Okay, thank you.
They will have to adjust to a different setup. Rania, please.
Thank you. So I just wanted, I'm not sure I understand this correctly. So I understand the provisions for someone who has already served as, a sustainability assurance leader. Whether PI, not PI, transitioned into PI, fine. But what if, let's say they started out in financial statement audits? I mean, let's say imagine a firm that is, let's say maybe this is not a realistic example, or maybe it is, I'm not sure, that has alternated between, let's say, financial statement audit and then sustainability assurance. Is that somehow covered here?
Yeah, it's all covered.
Yeah.
So every services that spent either as a financial statement auditor or a sustainability assurance leader. So that's the whole point, that they need to consider.
Any kind of assurance is sorry. So any kind of assurance service, okay, is considered in the calculations for the rotation.
Sustainability assurance, any kind of sustainability assurance under Part 5. Yeah, sorry, and other sustainability assurance as well. Yes.
But let's say today let's say I've been performing a financial statement audit for the past 5 years, 6 years, whatever, and now I'm being hired or engaged to perform sustainability assurance.
It is included.
Yeah. So I would have to be rotated off. That's
yes.
Okay.
After 2 years.
Yes. So the 7 years includes each and every type of engagement. Yes.
Okay.
Plus a little bit.
Thanks.
Go ahead.
I have a question. Whether the task force also has considered senior staff or, manager, senior manager. And now it's about the leader. So I was wondering why that's not included here.
So leader is a defined term. I wish I can quote but we are focusing only on the key sustainability assurance leaders from the perspective of the rotation, and it is determined in the code that who are these individuals. Yeah, so it's not all the staff.
No, not all the staff. That's also not what I was looking for. But is it only the engagement? It's not only the engagement leader, or is it more than only the engagement leader?
It's the engagement leader for the partner rotation.
Yeah.
Chana, please.
But there's also the general.
Yes, but in the long association section, there are general provisions to address the threats created by the familiarity threats created from the long
Senior
association.
managers.
But the 7-year partner rotation, the requirements focusing only on the leaders. Yeah, so they are not out of the hook.
Okay, thank you for the clarification. So, any other question on this or comment? Andy?
Thanks. I'm running a risk here because I usually like to give this more thought than just blurting things out, but I hadn't really associated long association and the fees before. But is there an avenue for the consistency of if the long association doesn't matter if the sustainability assurance in the Part 5 is mandated or not? Would that be a consistency in terms of the fee question we came up with? And I guess I'm just asking you all to consider, because you're not considering in this long association, right, if it's mandated or not, which I understand probably doesn't make sense, but that's why I probably should have kept it to myself, but I was just wondering if there was some level of consistency. And of course, you are tying it to Part 5, which has been suggested before for the other topics. So anyway, welcome to my brain.
Thank you for the introduction.
Okay, so I think that we reached the end of the presentation, right? Is that still?
Yeah.
Sorry?
Flowchart, yeah.
Okay.
Yeah, so sorry, so Sylvia, before we go to the flow chart, there was this matter on the self-review threat. I don't know if you're bringing that back on at some point or because
Do we?
scoping of the bullet point, if you recall.
Yes, we didn't want to bring it back. I don't know. My suggestion would be
To take it back to the work stream?
We will take it back to the work stream, and if board members have any comments on that, and they can send it via email, and that's something that we would take it back to the work stream to
That's fine.
spend
I
more
mean,
time on the discussion.
As long as it's clear what the question is.
Yes, so it's what Kenzie is mentioning is regarding the non-assurance services, and in paragraph 4600.15.a, there were some comments whether we should limit the reference to the records underlying the sustainability information to sustainability information on which the firm expresses an opinion, because currently we treat it in a broader level, and that's what we explained in the application material in the agenda papers. So I believe it's quite complicated, and maybe board members can give it some thought and let us know their comments, and we will also think about that at the October meeting, and I believe we will bring it at the next occasion if that's okay.
Yeah.
Is it okay?
Yeah, that's good.
Via email or
Please.
Yeah.
May I just ask you something which is related, which is not related with the technical proposals that you have been making? But since we are speaking about coordination, integrated package, all these things, there are already sustainability assurance reporting standards which are being used. There will be soon the IESBA standards. What would happen, and this is of course a theoretical question and not a practical one, but I think that it might help understanding the importance of this. What would happen in this specific space of non-assurance services, fees, and etc., if these standards, the IESBA standard, what we are suggesting, would not be in place? Imagining that they would not be approved in December, something would happen, and there would be times where, for instance, in assurance, companies will have to make their choices in terms of auditor and all these things. What would happen if we weren't to have these standards in place? Does Part 4A apply?
So with the best will in the world, Part 4B would apply,
Right.
where it was a professional accountant providing that assurance service. And although, we did talk about for things that fell outside of the scope of Part 5, we would encourage Part 4B to be used by by non-practitioners,
But
but there would be
that's-
no basis to do so. So if we don't have this standard, then 4B would apply for independence purposes in a sustainability assurance engagement, and nothing would apply in terms of someone other than a practitioner
But for
carrying out
instance,
that.
would an auditor who is the auditor of a company be able to appoint, to be appointed, that auditor be appointed as the sustainability assurance provider without this exception that we are?
So the auditor would still assess their independence in accordance with Part 4A of the code.
Yeah.
And you know, they would still be carrying out their own independence assessment. So in a sense, the greater risk of not having Part 5 available is not really one where the auditor is carrying out the assurance engagement. It's where someone is carrying out the engagement who is not the auditor, because we know that the auditor would be carrying out their independence assessment in accordance with Part 4A, and that already gives a high level of independence. It's where they're not the auditor and they're applying 4B, in which case you have two sustainability assurance engagements which are ostensibly the same, one carried out by the auditor, one by someone who's not the auditor, and different independence requirements would apply.
Okay, thank you, Mark, very clear. Luigi, please.
I agree to the extent that there are no local regulations stating something different. Like, for example, in my country, in implementing the CSRD, clearly stated that those assuring the sustainability assurance report should apply the same rule of an audit, the same, whichever they are. So it is true under a general perspective, but then we need to consider local laws and regulations.
And Luigi is absolutely right. And I think I would just say that the examples that we have at the moment, the European Union is the furthest forward in terms of the legal and regulatory framework that it applies. Australia has now put in place a framework for reporting and assurance, and that will catch up. But for a lot of other jurisdictions, it's work in progress. And so, you know, in the absence, as Luigi says, in the absence of domestic law or regulation, that's how you would apply the code.
Okay, thank you very much. I think that, oh, sorry, Andy.
I think a very intriguing question. I mean, I think the IASB standard refers to the requirement to apply relevant ethical requirements.
Yeah.
So then I guess the issue is what of all these would serve as the relevant ethical requirements, which may actually still be Part 4A, because they might be relevant even if they're not necessarily. So that would have to be sorted out, but I do hope that that's not something that needs sorted too.
Okay, thank you. But that also that again raises a concern about fragmentation if these standards are not made available very fast, because countries, jurisdictions will be making their decisions very quickly, and I'm speaking namely about Europe, Australia, etc., with respect of which ethical framework will they apply when they will decide on their assurance framework. That decision will be made now. It's not in 1 year, it's going to be made now. If the standards are not available very soon, there is a risk, which is already materialized. Luigi was alluding to it. We have an European framework, we have a lot of different frameworks. There is a huge risk that in 3 or 6 months, very quickly, there will be decisions made in this respect if these standards are not available and final very, very soon, and as close as possible to the IASB's standards, since it creates room for these things to happen. That's a fact. That's not imagination. It's a fact.
Like if I can just say, Gabriella, as well, sort of Andy made the point, the IASB talks about relevant ethical requirements. The whole reason for all of the coordination with the IASB is that Part 5 has been designed to be the relevant ethical requirements that apply in the audit of a sustainability assurance engagement. So, you know, without it, you have a sort of rather large piece of your wall missing.
I fully agree, but that's again why I'm highlighting this risk of disconnection in time, creating room for decisions about what's the relevant ethical requirement in each jurisdiction. And it can be many things, and sometimes it can be a little bit less relevant. And less consistent. Okay, so thank you very much for this very good conversation. I'm sure that the work stream will take all these comments on board. It's not going to be very easy to come up with something which satisfies everyone. But again, I would urge the work stream to stick to the core of this standard, which is to protect the independence and the level of independence of the provider of audit statement of audits and sustainability assurance. Yeah.
So we received quite a lot of requests to prepare a flowchart that will really demonstrate the proposed independence requirements in section 5405 and 5406. So we quickly put together something that I will put on the screen, and you may wish you would never ask for the flowchart.
Where is the flow? Okay.
Okay, so I will just put that one in the. Yeah. Yes. So again, this is something that we prepared this week. Obviously, some work needs to be added to this one to be a bit less complex, and obviously way more prettier than this one. But it's really just to demonstrate, and I will circulate that slide after the meeting, just to demonstrate that the decisions and the decision points when a firm is determining the relevant independence requirements. And we agreed that the first question that the firm should raise, that can the firm be appropriately and sufficiently involved in the assurance work? Because that's going to determine which section and which independence requirements would be applicable. And the answer is yes, that the firm can be sufficiently involved, that the provisions in section 5405 would apply. If no, cannot be involved, the firm is planning to use the work of another practitioner who is not an engagement team member, that section 5406 would apply. And now I would focus on the section 5405 column on the left. And the next decision point on the next question, the firm should ask that, is the assurance work performed at the client, including a group component, or at a value chain component? Because again, the independence requirements, as we agreed, differs whether if it's a group component or a value chain component. So again, if it's the client, so the assurance work is performed at the client or a group or at the group component. The next question is that, is the assurance work performed by the firm or a component practitioner within the network? Because that's the other layer. And if the assurance work is performed by the firm or a network firm, we require independence of the network from the client or the group component. So we are still in the group component column, but the work is performed by someone, by a component practitioner outside of the network. This is a similar scenario that we discussed during the ETGA project as well. We require independence of the network from the client, obviously, and independence of the component practitioner from the top parent and the entity through the chain of control. So it's really difficult to explain in such a small box, but you may recall that the ETG project, we had these flow chart, and we indicated that we are focusing on the independence of the practitioner outside of the network to the client and going down to the chain of control. So this is when we are talking about assurance work at a client or a group component. But if it's a value chain component, again, the question is the same, that is the assurance work performed by the firm or a component practitioner within the network? If the assurance work was performed at the value chain component by a network firm, that we require independence of the networks from the client and the value chain component. And if it's someone outside of the network, we require independence of the component practitioner outside of the network from the value chain component. And as we discussed, there would be no independence requirement for the network from the value chain component. So this is what's in section 5405. And on the other side of the slide is in section 5406, when we said that the firm cannot be appropriately and sufficiently involved and using the work of another practitioner who is not an engagement team member. And again, in that case, the question is that is the assurance work performed at a client or at a value chain component? If it's a client or a group component, our intention was that we create the same independence requirements that would be applicable if that person was an engagement team member. Recognizing that we cannot set out a direct requirement for the other practitioner, so we are requiring the firm to confirm the independence of that other practitioner in a similar way that applies to engagement team members. Of course, because we are talking about the client, the independence of the firms and the network firm from the group component is required. And the firm is also required to confirm the independence of the other practitioner from the group component. So we believe that is basically mirroring the situation if that other practitioner was an engagement team member. And on the other side of the equation is if the assurance work is performed at the value chain component by another practitioner. So in that case, we require the firm to confirm the independence of the other practitioner from the value chain component. But there is no requirement of the firm or the network firm to be independent of that value chain component because, again, this firm is going to rely or will use the work of an independent other practitioner. So that's just the first step of this flow chart that we will start working on, and I will share it with the board. But please do not circulate that as an official chart yet. It's really just for you to help the process.
Hey, have you changed the text in order to prepare this one? Because I do not find myself in the last row, third column, sorry, within, let's say, is the assurance work performed by the firm or component practitioner within the network?
No, we didn't change.
Okay, so I don't think it is consistent with the text, because in the text, it doesn't seem that the network should be independent from the value chain, because as it is written now, it is just the network firm performing the work.
I think that was, yes, I think that was our intention, but we will have a look at it just to be sure that that's what we wanted. But but it was that if it's a firm or a network firm who performs the work at the value chain component, we believe that, and I'm looking at the task force as well, that our intention was that the network should be independent of
those customers and suppliers. Okay.
Yeah, please work with 0.9, but not with 0.10.
Okay, thank you very much. And again, we will have a look at it to just to ensure that it's consistent with. Okay.
Yeah, and as Sylvia has indicated, this has really just been prepared in short order without really the benefit of a careful review by the workstream one. And I've myself have not had a chance to look at it in detail. But I just noticed, Sylvia, you might want to double check the bottom row, the second box that refers to outside network, where it says independence of the component practitioner from the top parent and entity's chain of control. that provision applies to the individuals within the assurance team, not the firm. That's number one. And number two, you need to also pick up independence from the group component. Whereas at the moment it is just referring to independence from the parent. So you need to capture the group component.
And
Not the parent, the way down.
And I think, you know, please let us have any comments, but the intention is still to do something that can fit on a single slide.
Yeah.
So
How big is a slide?
well, exactly, and it can't be a slide that's the size, sort of the
Freeform.
side of a lorry or something. So we, you know, I think the aim is to try and illustrate something in a way. So we've got to make sure that it's still precise enough to be clear about what's intended, but we do want to sort of try and demonstrate. And I think it was the challenge that you said, Janine, and others have said, you know, can you do something that sets it down? So this is a first cut of that. And we'll refine it as we continue to work forward, because we think it's quite a good way of communicating, particularly for the non-PA community.
Also for the PA.
And for the PA
as
as
well.
well.
So of course, Mark, and I just need to convey my gratitude and our gratitude for you for having been able to develop this in such a short time frame. I don't know. I was passing by here yesterday at 10 p.m. and thinking maybe they are still there developing the the flow chart. So thank you very much. I think that it visually results very well. So it's just a matter of if there are any tweaks, and I'm sure that there will be some given the time that you did not have and we did not have. So I think it responds well to the request to have a visual that supports our ability to navigate this very complex thing. And then the tweaks will be made to make sure that it is consistent with the text and all these things. So any comments conveyed to the work stream, having this in mind that this should be one slide, it will be good. Yes, Ken, please.
Not only on one slide, but also coordinated with the new colors of IESBA, which we will see tomorrow.
Okay, I think that again we are being very, very disciplined. More and more than that, we are finalizing this morning 5 minutes before schedule, right?
Yeah.
So we will have 1 hour and 5 minutes for lunch, which is fair because we did not have breakfast, so we need a little bit more time for lunch, and reconvene at 1:45. 15 minutes before the hour. Thank you very much. He's having lunch, I think. So I think that we should make a start and try to be as timely as we have been, if not much. The work stream one met during lunchtime, and I don't know if you have anything to report back now, or it's just for you to process. But I think that the time now would be to go through the full review of the proposals. Well,
So yeah, I think that's right, Gabriella. We've got a turnaround session tomorrow. I suppose the one thing we should say, much that distresses me, is Luigi was right on the slide.
Yes.
Luigi was right on the slide, on the flow chart.
On the network.
So we need to update that.
But the chart or the code?
The chart to align with the code. So Luigi's had his win for this week, so he can't have another one. So we will report that tomorrow. We're now going to go through and turn the pages. Please, can I just ask board members, where you've already sent in comments and you've already given us editorial comments, no need to make them again because we are sort of reflecting on them. So this is just additional things that sort of come through.
To any comments you
Yeah.
haven't raised so far, and it's important for us to know before we go to our
Yeah.
deliberation.
As far as I understand, just to be sure about the process, you will come back tomorrow.
Yeah, we've got a slot, I think, tomorrow afternoon, Gabriella, for
Yeah,
work streams to report back on issues that we've discussed during
Okay.
this meeting and how we propose to respond.
okay, very well. Janine?
I have a question about this. With respect to due process, could there be any relevant issues in relation to the public interest that would then not be raised? Because I think it's also important that if there are substantive comments that were made that are relevant, that they're maybe
So
debated here then, or mentioned here, or
we
for the
we
record?
will address those through the session tomorrow afternoon.
Oh, okay.
And obviously we'll go through the public interest considerations as part of that, reflecting back to you. There's also, I think, the quite significant piece of work, again, in the public interest about the alignment between where we've got to with the IEESB that was discussed this morning and feeding back on the comments from board members earlier this week. But we'll make sure we cover that off in tomorrow afternoon session.
Yeah, but also comments that you were saying, we have already received comments. Don't worry about those, in my own words. We will work with them and address them. My question is, if there are substantive comments that were sent in earlier that are relevant for, well, also for maybe have more than only some tweaks here and some wordsmithing, that there is a chance that others know about it, and also that it can be debated if it has a wider implication. That was a little bit my.
So we
the due
will
process.
have a virtual board meeting after we've had our next task force meeting. So that will be an opportunity to report back on any of those due process public interest issues, and we'll explain either how we've addressed them or where we haven't, why we haven't, and at least have an opportunity for a discussion there with the board.
But also, from workstream one perspective, I think the comments we received via email were really useful, and I don't think there were any substantial issues that haven't been raised within the board or debated. If there was any, as Mark said, we will raise that. But I think we mentioned the substantial issues at this table. I don't know if I believe that's the same.
Yes, Janine, I think that according to the due process, nothing is final until it's final. So there will always be an opportunity here in November to raise anything. Of course, the expectation is that we don't go back on things that we have discussed, processed, etc., and around which we reached a significant level of agreement, which, by the way, it's, I think, where we are very much today. Of course, the work stream still has to work on a few topics, but I don't think that at this stage, public interest topics which have not been addressed. Still, door open, of course, to any comments, but of course not going back, I would say, on what we have already agreed. But yeah, until the end of the story is there is an opportunity to raise those topics. And yes, as Mark was saying, we will have a call in November, and that would be a good opportunity to, I would say that more to consolidate what by the end of this week should be already a very, very, very close to the final version of the standards without major or even minor open issues, strategic issues, or public interest issues to discuss later on. So maybe we can approve it in November, use that session for that purpose. So, okay. Sunam, you also have a question?
Not question, just what confirmation. As you have done in the past, you're gonna, in terms of the comments you have received by email, you're gonna send us your comments or your way of thinking before the meeting in November? I don't know.
I almost certainly expect we will, Sungnam, but we've got a meeting in October where we will be going through
Board members
preparing
come.
everything and making sure that we've got material for board members to look at well in advance of the virtual meeting so that we make best use of everyone's time. But that will set out how we've responded to feedback.
Yeah, just for clarity, because I think it was not clear to you, the meeting in October is a task force meeting.
That's right.
Not a board meeting.
Right.
The board meeting is in November, on the 8th, I think, of November. Okay, so Mark, Sylvia, Christelle, Laura.
So we're starting with a page turning now, and we'll do it together, both work streams, and just for sake of the order of the standards.
That's sanity.
And our sanity, yes. We're gonna start with the work stream 2 related standards. And so we're gonna go through the changes that we haven't addressed yesterday, because regarding the others, we have discussed them yesterday, and we've taken your comments, and we will discuss them in October. And so and we'll do a section by section like we've done in the past. So in this paragraph, this is basically just accepting some suggestions from respondents regarding mentioning high quality, globally accepted reporting and assurance standards, and including some other examples of users of sustainability information. The changes in 5100.2, we've gone through them yesterday. In 5100.2a, it's just a cross-reference to the part of the independent standards where it is mentioned that what is outside the scope of part 5, and so therefore part 4b applies. In this, sorry, yeah, right. This next change is just to align with the way that we mentioned this in the NOCLAR. So fraud is an example of NOCLAR, so it's just a editorial change. We've gone through this change also yesterday, this new paragraph recognizing there are other codes of conduct that may apply to sustainability assurance practitioners who are not professional accountants. This is also an editorial change just to align with 5100.4c, where we use prepare and not present. We've gone through this change yesterday as well. It's just a cross-reference to clarify the scope of part 5. Here in 5100.6a3, it's just also to include a suggestion from one of the respondents saying that, especially for non-PAs, consulting with an appropriate body may not be sufficient or appropriate, and obtaining legal or other expert advice might be more adequate, and so we've included that reference. The next change is just to align with the definitions that we have in the glossary, which is professional services. I don't know if there are any other comments in section 5100 before we go to the next one. Okay. So here's the fundamental principles. We have a change here in 5113.182. This.
Sorry, Laura, I think that Chana had some comment.
I don't have an issue with I think I have issue with the location of this, because we don't have a similar thing the normal 113.1A2. And this is about something very specific, certain location-specific things. I mean, there could be a lot of things that are important from a knowledge and skills perspective. So I'm not sure why it has to come into 113. I mean, if it could be located somewhere else, then I'm okay with it.
Okay. This was also to include the suggestion of one of the respondents saying that for sustainability assurance, the professional competence, the relevant professional competence in terms of sustainability assurance depends or varies greatly in terms of the location specific characteristics. We actually, at the work stream, we've debated where this could go, the best location for this clarification, but we will take that into consideration and we'll look at it again. Thank you. Okay. Janine, please.
Yes, maybe one question. It's a sort of, well, the topic on competence is related. I read in the part 5, somewhere at the beginning, that there is the requirement that there is an expectation that the sustainability assurance practitioner has the right competence, skills, and experience.
Mm-hmm.
How does this word expectation relates to, is that, how to put it, is that consistent with what we require a professional accountant who is doing sustainability work, assurance work, versus a non-professional accountant who is doing sustainability assurance work? Because for a professional accountant, there is not something like expectation, I think. That's much more stricter. And is that then, is expectation the right word for part 5? That's my question.
Yeah, so that was something I think you're talking about, probably one of these first paragraphs.
Yeah.
This is something that we discussed, or the board discussed last year. This one, right?
Yeah. Are expected. Yeah.
Yeah, so this is something that the board discussed last year in connection with, so part 5 applies to both PAs and non-PAs who are providing sustainability assurance. So, and for both, there is that expectation. The reason why we have this paragraph here, which is a new provision that we don't have elsewhere in the code, where it applies strictly to PAs, is because PAs are a regulated accounting is a regulated activity, and there are certifying bodies and professional bodies issuing certifications and trainings and all of that. And that is not the case for sustainability assurance practitioners as a group of professionals. And so the board felt the need to have, since we don't have a certifying body with the authority to certify that they have the knowledge and the capacity and all of that, like PAs do, the board felt the need to have something, a provision here saying that, you know, you may not be officially certified to provide this service, but we expect you to have the relevant skills and capabilities and etc.
But I always had the impression that when you're a professional accountant and you're doing a professional service, you have to be, your competence and due care needs to be, professional competence and due care is a fundamental principle. So that would override, I think, what we put here in the code as the expectation. That's where my thinking came from, that it's an overriding fundamental principle that you always, it applies always. That's what you always learn when you're a professional accountant. And so I don't know what is then the leading position. Is it, if you're a professional accountant providing sustainability assurance services, is then part 5 overrules that the basic professional, yeah, if you do professional activities and your professional due care, competence and due care, So I think there is a mismatch then, or do I see it?
I'm not sure if there's a mismatch, because in part 5, professional competence is still a fundamental principle that again applies to all sustainability assurance practitioners. We don't see them, or at least I wouldn't see this as overriding the fundamental principles. I think it's just a reminder and an expectation for SAP sustainability assurance practitioners who are not PAs. PAs will still be subject to parts 1 through 4B of the code. And so, but again, in terms of fundamental principles, I don't see that as an issue, because we still have them in part 5 and they still apply.
But sorry, now it's me who is who have a question. Does it mean that for non-professional accountants, they are not required to have the necessary skills and knowledge? They are just
They are expected to have them. That's what we're saying here in this provision. And in case they don't have a certifying body, that's all we have. It's this provision expecting them to have that.
Okay. Yeah, I think it's yeah, I think I see your point.
Yeah, it's not so enforceable. Expected is,
yeah, okay.
It's expected.
I would say that's for jurisdictions to create those accreditation bodies, and right, I don't. So yeah.
On the 5100.1, the previous paragraph, would you like to mention regulators also here? I mean, they are covered, such as, so it's only an example, but I thought a specific mention would help.
Just on that one, sorry, just because we've only got until 2:45 to get through the page turn, if there are drafting comments, can we just email them into the team, please, and then we'll reflect on those. It's just I'm mindful of the fact we won't get
I just had one more mark, if you permit, then I'm done. So just go down on that page, 5102. Yeah, 5100.2B. Just go up a little bit. Just go up. Yeah. Please go up, further up. Yeah, so on this point, on paragraph 4, Roman 4, encounters suspected fraud or other non-compliance with laws and regulations such as fraud. So I liked your previous drafting better, because non-compliance with laws and regulations such as fraud is more than just non-compliance. So perhaps fraud should be specifically mentioned separately, not just the non-compliance. Thank you.
Yes.
That's the code. Oh, yes, yeah, that's because in the no cross section, non-compliance includes fraud as an example. So we understand your point, but that's why we made change. Non-compliance includes fraud.
Yeah, it does.
Yeah,
But
said, the current code said
fraud is much higher. It could be, much more than just a mere non-compliance. So we need to make a distinction, I thought.
In the sense of the code, I don't think we may make a distinction between fraud and other non-compliance, which, by the way, could have huge consequences, more than some frauds. So it's not a question of a level of gravity, or it's a drafting convention. Fraud is included in non-compliance in all the code.
One suggestion, just going back to something that Janine said, where she was a little concerned with the word expected to, and something that you responded to, Laura, where you said it's already included in part 5 of the code. What might be helpful, just to help address that specific issue, is make reference to the other section. where the competence is drawn out. Maybe that would be a way to call it out a little bit more without necessarily changing the word. I'm personally not troubled by expectation because to me, it's okay, but I think maybe the reference to reinforce, given that you said it's already there, might be helpful. Just a thought.
Okay, thank you. So you will see what to do with these comments and come back with the final drafting. Ken, I thought you were say something. Okay, no. Okay, so let's move.
So at the end of section 5110, there's also just a clarification in 5115.21a. A conduct that might adversely affect public interest, public trust, I'm sorry. This is also just a suggestion from a respondent. And then in the last paragraph in this section, we have the same change that we made up there regarding the obtaining of legal of other expert advice. Then in the following section, we have a change here in the, when we talk about ISQM1, we had one responding saying that such as ISQM1 was not clear enough, and it seemed they were not clear about what we were trying to say here. And so we just pulled that reference there and made a whole sentence saying that ISQM1 is an example of a standard that recognizes the role of farm culture. Chana?
My comment there is designing the culture is not enough. You'll have to design, implement, and operate. Otherwise, you have it on paper, reality is much different.
Thank you. There are no other comments. I will just continue. Then in section 5270, the pressure to breach the fundamental principles, we've gone through this revision yesterday. We've also gone through these new examples of pressure here yesterday. The third one is actually just a move. So it's the one that we deleted, we just put it higher because it's another example relating relating to pressure coming from a client. And so we put it up there. Then for section 5300, yeah, this is just for clarification purposes. Again, this is the same paragraph that we have in part 3 next in the accent code. Again, there were some comments from respondents saying that this was not clear enough. So we just made it clear and made the same conforming amendments in part 3. Here is again, we tried to streamline the drafting a little bit, so we've deleted a few words here, and the example was not drafted in the best way. So it seemed that we were talking about the threats to the fundamental principles in the example when we're actually talking about the evaluation of the threat, which is what the paragraph is talking about, because it's the evaluation of the level of the threat. So again, it's for clarification purposes. This part has been added by workstream 1. It froze?
Yeah, that's really good.
We haven't made changes to these sections here in the middle. And then we get to NOCLAR. There's a change here regarding the scope of the NOCLAR that is included in this section. we removed impacts because we received a few comments saying that it's not clear what you mean by this word. And so we've eventually decided that what we wanted to convey is already included when we talk about the material amounts and the disclosures. So we realized that we did not need this word that we had proposed adding. This is just an editorial change. Here we added a reference to the importance of complying with the principle of confidentiality. It's a fundamental principle. We suggest adding this because, again, there were a lot of comments saying that, no CLAR must be subject to the principle of confidentiality. And yes, it is a fundamental principle, so it has to be complied with throughout all the sections of the codes, but taking into consideration that part 5 and it's going to be a new set of standards for practitioners who are not familiar with the codes. The workstream thought that it would be useful to have this reminder more explicit, and so it's something that we're proposing to add in part 5 only in this paragraph, since in part 3 we expect professional accountants to be familiar with the code and know that to comply with the code they have to also comply with the fundamental principles, including confidentiality. We've gone through this change here yesterday, the reminder to management of their responsibilities. We've gone through this change also yesterday, the requirements to communicate or consider to communicate, the list of factors, and then the coordination between the sustainability assurance practitioner and the auditor in the situation of no CLAR. Yeah, and then we get to the tax planning section where we made also no changes. And the last section is the use of an external experts, and then we go into the independent standards.
So then I think we arrived to the international independent standards. We didn't do as many changes as Workstream 2. So regarding the section 400, I think the changes we made is mainly to editorial. We restructured a couple of paragraphs and added some clarifications. And there were some changes that resulted from, again, the restructuring of section 405, section 406, and also to the reference that we mentioned before, that in the ED, we made a reference to the firm being able to direct, supervise, and review the work. However, in line with ISSA 5000, we are mentioning now that the firm being appropriately and sufficiently involved in the assurance work. So I think these are the changes that we made in section 5400 here. Again, regarding the PI session, we discussed and we mentioned that we added a new provision to explain laws and regulations, providing PI definitions for sustainability assurance engagement. And I believe that's it. So I'm just asking the board if you have any comments on section 5400. No. Yes. Luigi?
Yeah, on paragraph point 12A, second row.
12A, sorry. Yes.
Yeah. Sustainability assurance firm, but is not be able to be sufficiently and appropriately involved. This is not be able, shouldn't be, and might not be able in the construct of the statement. Or something like that.
Might intend to use the assurance, but the firm. because it's not a might. I think it's an affirmative, is not able. It's not whether it is able or not. So I think the present tense is correct here. Because it's the firm might intend to use. There are two options. Either a firm is able to be involved or not being able to involve. So I don't think that it's a might.
Yeah, there is something wrong there.
Oh, it's the B. Okay, yeah. Then we will just use the past tense and delete the B. Yeah. Yeah. All right, then is that okay? Okay, any other comments on?
Just one.
Yes.
On the PI, just the need to communicate in case the auditor, the financial auditor determines the status of an entity as PIE, should he communicate that to the SAP?
And that's what we discussed yesterday, that we received comments. So in the ED, there was no requirement for communication on the PI status, but simply because, and we believe that so we didn't propose any changes because we believe that the sustainability assurance practitioner has all the information that is necessary to make a judgment on the PI status.
So my point was, he may not be, I don't want to say competent enough, but if he misses it, if the financial auditor notices, and is there any harm if we bring in that guidance that he's supposed to let the SAP know that it is a PIE?
But it's not a requirement, so they can communicate. There is no, if it's in line with the confidentiality, but they can communicate, but it's not a requirement, and we don't want to make it a requirement because simply we believe that the practitioner has all the information of the client that is necessary, all the information of the national laws and regulation applicable to PIs, and also because we do not require the practitioner to follow the PI rules if the auditor decides to treat the entity as a PI voluntarily. So there is also no connection with the voluntary application. So we discussed that point, and actually we tested it with different scenarios, and we believe that it's not necessary to have a specific communication. And the other thing, that there is a public disclosure requirement for the auditor to disclose whether the entity is a PI or not. So the sustainability assurance practitioner can get information from that communication as well. But if there is no communication, all the information is available to make that judgment. Any other? So 5405. I'm really bravely going there, noting that indeed
There isn't anything in the rest of 541.
we received all the comments, and we will consider those. So maybe if you can raise, if you have any comments you haven't raised so far that we need to be aware of before.
Well, this is not a comment, just a question. Maybe I'll have my daughter give me a tattoo with that, but are any of the issues that the IESB told us about today going to affect any of the drafting we have in the 5405?
We will have a look at it, of course,
Okay.
but we are focusing only on changing the definitions or like, and tomorrow we will come back with our proposals regarding the group component, value chain component, but at the moment, but of course, we will take everything that we heard from the board, and at the October task force meeting, we will discuss this point regarding the independence.
Well, then I'm sure you have my comments on value chain components.
Yes.
And they have remained unchanged. Thank you.
Thank you.
Thank you. It is really difficult to state something when we know that this section and the following one requires some significant changes considering what we discussed in these days. I still am struggling, but it is a comment I already raised, to understand what perform assurance work at means, because sometimes it is used in a way, sometimes in another way, sometimes it is the direct or indirect through the other component, and frankly, it has not been yet considered and rectified in order to make it very clear. And again, since I do not have a clear understanding, also on the basis of the visual, it's difficult for me to take position. My first reaction, which is still to be say reviewed on the basis of the final text, final confirmation where we need to be independent, and how. My first reaction is that the full independence with respect to the value chain entities is too much. But frankly, I need to see everything, and then I will be in a position to say, well, I am in disagreement or I am in agreement.
And there's,
And I think hopefully, Luigi, tomorrow, when we bring back the revised definition in respect of group component and value chain component, that will help in terms of the independence requirements, and then subject to the board being content with the changes in that definition, we'll then go and replicate those through these sections.
If possible, please consider also, because I noted in the flowchart that you presented that it is embedded already in the flowchart, but still the perform assurance work art sometimes is a mix between different meanings, or at least could be read, and I read in this way, so sorry for that. So this is me. I read in a way where I was not able to go through the graph in this way.
And there was no intention to use the perform assurance work at in different meanings. So our intention was use it consistently. But again, as we mentioned, this is something that we cannot really address at the standards or provide a guidance to that. This was the same issue in the context of the audit standards, but as Mark mentioned, I think when we come back with our clarification, that will also clarify some points. But we know that, and we will work with IESBA to develop some guidance that could be helpful and to really explain what these perform assurance work at cover. But so we know that point, and we will further discuss that.
Yeah, the last point, then I will stay silent on this point, on this matter. The guidance will be helpful, but would be too late. So I think that you should try to make it very clear here, each scenario, when each scenario applies. So if the group assurance firm performed directly without making reference to any component or another practitioner, what's happened, and should not use probably the terms perform assurance or at, unless you also qualify, and I'm not suggesting that this is the way, but unless you qualify in a way that where we understand which in this case is directly performed without the use of any another practitioner component, or indirectly through.
No, it's not our intention to cover the indirectly. So if they are using the component practitioner, another practitioner, that's a different scenario. That's addressed separately. So responding to your question, although I don't want to provide a response to that we would capture the direct, that performing the assurance work directly, but based on the example you provided, that's what we mean under that, because if there is a practitioner involved or another practitioner, that's a separate scenario.
So maybe just Sylvia, just a quick note for work stream 1 to go through basically the entirety of section sections 545, 546, and anywhere else in the IIS where we use the term perform assurance work at, to just double check that the meaning is crystal clear, which is what Luigi's point is, so that we're not potentially inadvertently using the term to mean something else. And we have to also cross-check on the IWSB side as well.
Absolutely, that noted, and we will do that. And okay, so 5405, I think I would move on. And 5406, again, any comments that you haven't raised so far on that section?
Luigi, sorry. Can I raised the comment just to confirm that you are considering it, the concept of changing changes in the value chain components as for the group components in 406.
We are changing, or we will propose.
No, let's say you have
You've got a requirement to there's
you have a paragraph
red
changes
line
in
about
group
where it
components.
changes, and Luigi was asking for the same for value chain.
If you may, so I'm maybe I'm not remembering in that comment, but I'm sure I have it in my notes, and
Okay.
we will definitely consider that. So apologies if I don't know and I can see that Rich has a comment as well. Cannot hear you.
Mute, Rich.
Yes, thank you. I mentioned this briefly yesterday, and you don't have to go back, but in 54059 and 540.910, they're both requirements. I don't see why they're even in the standard. And so I'd ask you to take a hard look at what that is about, because it doesn't make any sense to me from reading it several times.
5405.9
9 and 10 right there.
It's I think its requirement, it's necessary because it's basically providing the independence requirements when it is the group sustainability assurance firm that performs the work.
Performing assurance work.
Didn't we already establish that you had to be independent back in 5400?
5400? No. Here we are. That's the requirement when we are stating that the group firm needs to be independent of the client, basically, and the group firm needs to be independent of the value chain component where the firm performs the assurance work.
Yeah, but the standard we've set is where they I guess, are you differentiating when they perform the work versus when they have sufficient and appropriate involvement? Because that's what I meant by the standard we established.
Yes, there are two scenarios that when there is the group sustainability assurance firm that performs the work. Recognize it's not it's an unlikely scenario, but that could happen if that it's the group sustainability assurance firm that performs the assurance work directly at the value chain component. And there is another scenario when it's a component practitioner within the network that performs the assurance work. So these are different scenarios. And point 9 covering that first one.
Okay, then why in 10 is it only the network, and 9 it's the firm or the network firm in the second line in both cases?
I think there is more about consistency, Rich, consistency with the ETJ provisions addressing audits of group financial statements. And it is that sort of equivalent approach that's essentially leading us to where we are. So we're trying to maintain, and Sylvia can correct me if I'm wrong,
Okay.
but Sylvia, I think we have basically aligned the provisions in sections 545 to the provisions that apply to group audits.
Following
okay,
the same.
thank you. I'm good. Thank you.
Andy?
Since we made a little pause here, I just wanted to use the opportunity to, Rich did point out 5.9, which I made comments on other paragraphs, but I think given what Ken just said about the use of a performing assurance work, even though I didn't call out this paragraph in particular, I'm sure you understand I have an issue with this paragraph too. for the same reasons that I
For the
have for
same,
them.
yeah,
Yes,
but we will
okay.
consider it.
Great,
yeah,
great.
Throughout the section. So 5405, 5406, I cannot see any comments on 5406. Then, as we mentioned, we deleted, sorry, Sadia, do you have a?
540517A1. I just wanted to confirm if that paragraph was in or out.
It's in.
Because yesterday we said 56006B is out. Right?
Yeah, but the 16, 5405, 16A1, explaining that when there is a component practitioner outside of the network performing assurance work at a non-PA component.
Sorry,
17A1,
yes,
that's what we are referring. Yeah, so this paragraph explaining that where is a component practitioner outside the network performing assurance work at a component that is a non-PI, that practitioner shouldn't follow the PI provisions just because the client is a PI.
Okay.
It's something that when we had the information session, we received quite a few comments that it is not clear whether the PI or the non-PI regime would apply, depending on whether the client is a PI or not. So we just clarified that if it's a component practitioner outside the network, that practitioner should follow the regime applicable to the component, depending whether if it's a PI or not.
So usually when we have a requirement for a PI, then we discuss if it's a non-PI. And here we seem to trying to be, yeah, we're putting both of them together. And that's what I'm struggling with. Do we need another paragraph for the alternative? If you're a PI, this applies. If you're a non-PI, that applies.
I mean, that's because that's exactly we are explaining that if the client is a PI,
yes,
we don't require that provisions to go down to the value chain component level.
Right.
We require that in the component, in the group component level, but not in the value chain component level.
I think the answer is we'll have a look to see if there's a better and clearer way we can say that, because I think the point that you're making is it's a bit unwieldy to have the not required to comply, because it.
And I guess what I need to point out to myself is that there's a subheading a few paragraphs before that this just deals with PIs. It's not dealing with the non-PI. Okay.
Yes.
We will have a look at it because we got a question from Rich as well. So we need to do some more work too. Okay. So 5405, 5406. Then
New attempt.
Yeah, then as you can see, we deleted 5407 because the requirements have been allocated to these two sections. And in 5410, we didn't make any changes. And I think I would just skip those provision sections, because the next section where we made any changes, it was 5540, the long association. But please stop me if you have any comments on those. But there were no changes from the ED on those paragraphs, on those sections, sorry. Okay, so in 5540, the long association, we discussed the changes we proposed. We proposed some guidance to explain the potential scenario when there is a non-part 5 engagement that becomes a part 5 engagement, how we calculate the time on period. But that's the only change we made to this paragraph, and I believe we collected your comments on that. And 600, again, Keys presented that in the 600 part, we proposed some clarifications in 600.5a, 6a, and as we mentioned, we're gonna delete 6b. So I don't believe there were any other changes. We will come back to 600.15A, but that's something that the task force is still considering. So if there's any changes, we will report back at the November section. But that's all the changes. Is there any other comment on 600 you haven't made? So on 600, then 601, sustainability data and information services. Keys presented the changes, the clarification, and the examples. We recognize the comments we received that sometimes we meant to be helpful, but maybe we were too helpful. So we will go back to those examples and we will have another look at it. So 602 administrative services, there were no changes. 603, it's the valuation and advisory services on forward-looking information. Again, there were some changes on the title to better capture the description of the services. The changes you can see on that is mainly to adjusting to the new title. So 604 tax services, again, we received comments that we need to reconsider the additional guidances and examples. We will do that.
I mean, and just to be clear, that the examples were added really in response to some of the comments that came in saying, could you add some comments to sort of demonstrate why this is relevant to sustainability? And I think what we heard earlier in the week was, well, if you're adding an example to the end of a bulleted list that already exists of example, that's possibly fair enough. But if you sort of suddenly add an example into the end of a paragraph, that is possibly a step too far because we don't do it in the audit section. So I think the answer will be, well, generally speaking, we'll probably take those examples out, but we might consider including them somewhere in sort of basis of conclusions or explanatory or FAQs if people want to say, here's a demonstration of why tax services are actually relevant, for example.
Sadia?
And maybe it's a principal comment that sometimes I find that we're making cross-references and I'm not sure it's entirely helpful. So as you go forward, the cross-references sometimes makes me question, are we doing all the cross-references then?
Okay.
And I don't want to get into that thing where we have to start updating things
Okay.
just to make sure it's complete.
Noted, then we will check that. So maybe I will not go through all the subsections. I will just ask generally if you have any comments on the subsections in 600 on tax, legal services, corporate finance services.
Just clarifying the corporate finance, because it wasn't an example of a service, but it was a reason. It was on the promoting shares, and I added a bit in that said this doesn't apply if that doesn't affect the sustainability information. When I heard from Norwegian, I think the rest of the board has agreed as well. Irrespective of whether it affects the sustainability information or not, you wouldn't really want to be promoting the shares of your sustainability assurance client. So I'll take that sentence back out again.
And I think that's on, we deleted section 5700. So that's gone and no new requirements in that. There, I would like to just point out a couple of changes to the glossary that we already presented to you yesterday and on Monday, that on another practitioner, we made some changes that were on the slides to fully align the description of another practitioner to IESBA 5000. So that's what we did here. The other, so again, we talked about the component definition and group component, value chain component. As Mark mentioned, we will come back to you tomorrow with some revised wording. We also added the component practitioner that wasn't part of the ED, but this is something that assurance standards used as well, and we wanted to be aligned. So we also added the component practitioner, and the component practitioner is someone in whose work the firm can appropriately and sufficiently involved. So I'm just checking. The rest of the changes are only consequential. There is one more. Yeah, the group component.
Delete the operational.
Yes, we will update that. So in the group sustainability assurance engagement and to group, we only make some clarifications, I would say, and also just to use the same wording as IESB is using, but no significant changes over there. And in the key sustainability assurance leader, we added an explanation at the end. I think that's what I mentioned before as well, that task force was of the view that a sustainability assurance leader performing work at a value chain component wouldn't meet the criteria to become a key sustainability assurance leader. So whenever we are talking about key sustainability assurance leader, it's only referring to leaders at a group component. And I think we added a reporting boundary definition because that's something we are using in the determination of the component. And the reporting boundary definition is again the same as provided in the ISSA 5000. I believe that's it. Nothing else. So regarding the consequential amendments, that was the only amendment to the fees section, but we discussed that. So that's all. Yeah.
Thank you very much. Yes, Andy, please.
No, thank you. And thank you for this. I've just been mulling over actually Janine's comment on the second paragraph, which about the expected to be competent, expected to have relevant knowledge and skills. And I'm also, we had a couple paragraphs where we got to the ISQM1. And I know in the auditing standard, it's a premise that the practitioner adheres to ISQM1 or something. And I guess I'm seeing where the requirements are to comply with our standards. You have to meet where there's an R paragraph. And so how is a statement of fact like an expectation or a premise operable as an enforceable requirement? And maybe after 6 years on the board, this is an embarrassing question for me to ask, but I guess before we let this thing go out to the world, I guess I just was concerned to make sure I understand, because I think we probably all agree that should someone who doesn't have the requisite knowledge, skills, and experience perform that's not in any public interest, should someone not meet the premise of an ISQM1 or adhere to our ethical standards, that's not in the public interest. So could you help me with, or someone help me maybe to later, or us all with the elevator speech on how an expectation as a statement of fact is a requirement that's operable?
I think the answer to that, Andy, is it's going to very much depend on how your enforcement regime is set up. But if I give the example from a UK perspective, we enforce where there is a failure to meet a relevant requirement. So the application material that sits around the relevant requirement is context to the interpretation of that, but actually the enforceable matter is where you breach a relevant requirement. So in a sense, you can create an expectation, but if the expectation is not underpinned by a requirement, then it's impossible to find a basis to enforce against.
Well, maybe you've just now restated what I think our concern is, yeah, because that is the issue, that if you're looking for the R's and you're saying, oh, if it's not an R, we can't enforce it, or you can't be said that you're in violation, then anyway, I'm just again, you sometimes hear too much of my thought process in a public forum, but I thought I'd raise it now.
I'll try my best. The way I read the provision in section 5, and I cannot remember the exact paragraph number, but it's in section 5(100). That provision is essentially conveying a message. The message is essentially that if you're going to be performing sustainability assurance engagement, well, you better be competent, you better have the necessary skills, experience, whatever it says. But this expectation essentially is operationalized through the requirement for the PA to comply, or the system assurance practitioner to comply with the code, and in particular the code requirements that deal with competence and everything that goes with competence, expertise, etc. Right? So that's in section 113, 5113. So that is essentially that it's when it's couched in, sorry, when it's positioned in section 100, it is a message that provides a context for what then comes through in terms of the provisions and how then section 100 tees up the other sections that come afterwards. You know, you have sections 5300 that deal with the general provisions for any kind of professional service. And then you have section 5400 that deals with the independence requirements. So it's in the sense of a message. That said, there are other places in the code, and I'll just give another example, where the use of the concept of an expectation is more in the sense of an aspiration, in the sense that there isn't a requirement behind it. So for example, in section 200 in the code, there is paragraph 200.5A3, which deals with the expectation for senior professional accountants in business to essentially, it's an expectation directed at the senior PIBs, if I can read the words here, that to the extent they are able to do so, taking into account their position and seniority within their organizations, those senior PIBs are expected to encourage and promote an ethics-based culture. So there isn't a requirement placed directly on the senior PIBs, because clearly the issue enforcement is an issue that's going to be very significant and a practical issue. But the message is clear that if you're a senior PIB, like you might be a CFO, for example, or even a CEO, but you happen to be a professional accountant, the expectation is that you essentially use your authority or level of seniority and the sphere of influence that you have to encourage and whatever the code says, to encourage, to promote and encourage an ethics-based culture. So I think we have to read the expectation in context. And as I say, in the contexts are slightly different in the two different sections I've used as examples.
So I see like 5110.2, a sustainability assurance practitioner shall comply with each of the fundamental principles. One of the fundamental principles is professional competence and care. So that is an R paragraph. Mm-hmm. So so I understand that. So the 1A paragraph that we just kind of stumble, I mean, in a way, it's a little awkward as you get there, especially at the second paragraph, is just more of an introductory, contextual, as opposed to it. So our job is to make sure that there aren't any expectations that are underpinning of professional services that are not manifest in an R paragraph.
Insofar as sustainability assurance engagement is concerned?
Oh, throughout the entire code whenever we do something. I mean, it has to be in an R paragraph in order for it to be a requirement.
Correct. But if your question is whether there should be a requirement underpinning every expectation that's articulated in the code.
No, but this was a fundamental expectation that the one that Janine pointed out, 501.1A.
That is a fundamental that's underpinned by a requirement in the code, absolutely.
And so the real answer is there's a requirement to adhere to the fundamental principles. The fundamental principles have due care and professional conduct.
Correct.
And so there is no gap.
There's no gap, no, not at all.
And it applies equally to professional accountants and non-professional accountants.
Absolutely, yes.
So I think that was mostly, if I can read your mind, your concern that there was the same level of requirement and expectation to both professional accountants and non-professional accountants.
On a related but different set of standards is the ISQ1 question, which is the premise upon which the 5000 is based. does that have a similar sort of underpinning? Like could someone purport to comply with 5,000 without having ISQ one? Or it's something at least equivalent?
At least as equivalent,
Yeah.
yes. But the obligation to comply with ISQM1 or something that's at least as demanding is actually in the assurance standard. It's not for the code to establish that sort of obligation.
Is it? I may have misread it. I read it as a premise, not as a requirement.
Well, it is a promise, but it's not for the code to be imposing that requirement, because that requirement must be imposed through the assurance standard.
So-
And that is the case today.
So I'm just raising a flag. Has anyone imposed that requirement? So,
I thought, I don't know which number, I also read about an expectation that there is quality management. And I also noted that if you're another practitioner, then there is not in the code, the quality management is not dealt with. Only the relevant ethical requirements. That was a question I wanted to raise tomorrow, but since it now pops up in relation to because I was thinking that's also good to highlight in a flow chart, who has also an expectation for quality management. If the group as a sustainability assurance practitioner is not able to be sufficiently appropriately involved, then you have another practitioner. That can be a group component or value chain component, but I have made notes, only the relevant ethical requirements apply to using the work of another practitioner. And not the quality management.
So
somewhere in the code, I have
so
to look into it again, which number it exactly is, but
the hook for it, Janine, would be in the audit context. You've got the requirement for quality management that sits in ISO 220. So that's your hook that takes you into the quality management standards. So in a sense, you've got a requirement in 220 for quality control in the context of an audit that requires you to have the quality management system.
Yes.
And in the underlying reasons. So similarly with ISSA 5000, that is a single standalone standard for the assurance of sustainability information. So again, as an assurance requirement, they have the requirement to use a quality management system at least as demanding as ISQM1. We don't specify, in a sense, we don't specify what quality management standard you use, but we do say within the code that there's an expectation you will have a quality management approach, but we don't specify what that is. But in a sense, what you're looking at is the quality management requirement sits on the assurance side of the fence, and that's where the so if you wanted to take enforcement action against someone for not having an appropriate quality management standard in place, you would either do it because there was a breach of a relevant requirement in ISQM1, or because there was a breach of a relevant requirement in ISO 220. So the parallel to that would be if you had an enforcement requirement on quality management from an ISSA 5000 perspective, it would be because you breached a relevant requirement in ISSA 5000 that required you to have appropriate quality management.
But could you check just to be sure that this still aligns with IEESB? Because for value chain, now based on the code, if you're another practitioner, the expectation on having quality management is not mentioned. Because and I'm not sure if that is on the IEESB side, how that is now after they made their changes for this meeting in the standard, because quality management standard applies.
So because
for many kind of services, yeah.
Apologies, I was just because it's in the assurance standard. So the assurance standard set out the criteria for the firm to be able to use the work of another practitioner, and also like the competencies, the skills, whether they are subject to quality management. And one of these criteria is the relevant ethical requirement. So in the code, we are only providing the relevant ethical requirements, and any other conditions like the competencies, the skills, and the quality management is in the assurance standard. And it's on IEESB to require or to set these criteria, and not in our. So in that sense, we have.
I
no-
agree with that. So this Ice Cream One is in also under IEESB sets that standard, but and also they require or at least as demanding as Ice Cream One quality management standards. But it's about but maybe I come back to that tomorrow. Then I can pinpoint which code article in the code. I mean.
It's so because I think you raised that in the context of another practitioner.
Another practitioner, yeah.
So that's why I'm mentioning that the criteria to be able to use the other practitioner, it's in the assurance side. So it's the same.
Not in the code.
Not in the code. So the competencies and all the others, it's sitting on the assurance side, and the code only providing the relevant ethical requirements for the firm.
So if it was to work the way that you've articulated it, Janine, it would almost be that IESBA would be setting the quality management standard, not the IAASB. But actually, the way it works is the other way around. That the IAASB sets the ISAs and the quality management standards, and we set the ethical and independent standards that effectively underpin the conduct of the engagement. So what we have is a reference across to the need for there to be an appropriate quality management, a system of quality management, but it is not up for the code to specify what quality management arrangement you use.
Just like for an audit.
Yeah, absolutely.
That's
Just
right.
just as the same for an audit.
Yeah, and just to be clear, that ISQ on one applies to the firm that is the reporting firm. It's not indirectly almost, if I kind of understood your train of thought, it is not that the firm that is reporting on the sustainability information needs to require another practitioner to comply with ISQ on one, because that's not in the assurance standard. The system, the quality management standard that applies to the firm applies to the reporting firm only. And it is up to the report. Yeah.
Okay, thank you very much. We will hear tomorrow about your reflections upon these comments that we still had, but I think that we are we made great advance. So the next topic in the agenda is.
Yeah, I would suggest maybe 10-minute break to allow a changeover in terms of
Okay.
teams, etc., and then a short break so people can get some refreshments.
Okay.
Yeah, and then come back.
It's supposed to be.
We can continue.
And every minute is break. Okay, well, now then maybe
15 minutes.
Okay, 15 minutes break, okay?
Has a range of facial expressions. It's quite funny.
That's almost. I thought that she was so expressive. That maybe Christian should be. He should be sorry for her. And not for
Kudos to you for steering it. It's not easy.
I
I
told
think,
him.
in high school, I was part of
When
some
we
things.
Karen said, "I think that you," and she was like.
Through your
That's
day.
why it's so good to have in person. She made me laugh.
No, I saw that.
And,
It was so funny.
it's not a full-time job.
Very painful.
I was involved in mainly their assessment committee.
No, she's a sweetie, but no, she's very
That
sweet.
committee, the
Yeah.
guardian of the principles, also the fundamental
I think,
principles of security.
I think we're going the right way.
So they also keep revising those principles.
Yeah.
But that's like once in a while.
Yeah.
Compared to ours, it's too well. I agree. They have a lot of color.
We should tell the IWSB certain things, you know?
Yeah, but it's true. They all look like the same. I can't distinguish them.
They all look the same.
They're all the same
Yeah.
profiles.
Yeah. Yeah. Keep on breath.
So welcome back. We'll start now the last session of the third day. And this third session is dedicated to the CIVs project. We will be updated by Jean and John and Rich about the progress made by the group. I'd like to recall you that this is the first staff-driven model project that we have. So it's been driven, as the name says, by the staff, but of course, keeping in touch and in connection with the board and some board members, whom I take the opportunity to thank for the helpful support that they have been providing. As we move forward, and when I say we, it's staff and leadership and etc., thinking about how this staff-driven model should evolve. But I'm very grateful to this first team putting this in place. It's not an easy task. They have been very successful. It's a learning by doing process. But so far, we don't have any reasons to think that this is not going to be successful. So thank you for your great effort, autonomy, professionalism, and maturity in dealing with this. And thank you to Richard Fleck also for the support that Richard has been providing to the team. For personal reasons, Linda Bick, who is the leader, cannot be with us today and this week, but Jean and John and Rich will drive us through the proposals or the progress that the group has made. And I'm going to pass you give you the word. I don't know who's the first one, Jean? So,
Yeah, and sorry, John, just before you jump in, just a note to the board that the slides have been circulated to board members and everybody else. Some of the emails have bounced back, maybe because of the size of the document. The slides are available on the website. So on the board website, where all of the agenda materials are posted, you will find the slides there, and you can download them from the website.
Thank you, Gabriella, and good afternoon, everybody. Super excited to speak to you about CIVs this afternoon, a little bit of a shift from sustainability. So I want to thank everybody that provided advanced comments to us. We really appreciate it, help us form our thanking those board members that made themselves available to help us shape the thinking as well, and also those that helped us in arranging some stakeholder meetings with key stakeholders. Really thank you very much for helping us to achieve that. So on the agenda today, the structure of how we are approaching today is just to give a little bit of recap as part of the introduction. And then we've invited Rich Huskin, and really want to thank him for his time and preparation for presenting for us the practitioner's view and present that during today's discussion as well. And then the flow of the agenda is to the questions that's addressed in the paper. And we will pause after each section to get the board members' responses to those questions. In the closing, it's basically that we'll just open it up for any additional comment that wasn't addressed during the questions, if there's anything else that the board would like to mention to us as well. So as part of the introduction, as Gabriella mentioned, this is the first IESBA staff-driven project, with the team members being Linda, John, myself, and Richard Flick as the consultant. This is a little bit different as how we approach it. We don't have a task force, we don't have a working group, but we have been engaging with board members as well. So that's really helped us to get to where we are. The terms of reference, we spoke to this every single time, and I just want to reiterate again what are expected of us. This is expectation that is set by the PIOB for us to explore specifically collective investment vehicles as well as pension funds, to have a better understanding of these structures, as well as the parties involved and how the independence provision, as well as the related entity definition applies to them. And then there was that call to look specifically at the investment company complexes and consider how the code could be enhanced to address some of those aspects as well. So that's where we've included in every single paper to date as well, specifically on investment company complexes and how the SEC independence rules apply. We followed a mixed research methodology, and that is where we've done desktop research. We mentioned this before, as well as questionnaires and interviews. And I thought maybe just to pause a little bit here and say what the questionnaires were. So these are questionnaires that we developed for CIVs and pension funds, and we asked questions to different jurisdictions on how the governance structure look, who's the parties involved, what are they responsible for, are there any auditor independence specific provisions, either that they adopted to their code, or whether there's regulations or laws that dictate auditor independence specifically. So the people that responded, or those stakeholders, are not always those in practice. So sometimes we did not get that side of what the auditors are expected from, but we got the regulatory part, the laws, how that is structured, through those responses. We followed up the interviews with, the questionnaires with interviews, delving in a little bit deeper, asking those questions to get a better understanding, to help us form our opinions and the views that we are sharing with you today. What we also aim to do through the paper as well as today is to respond to some of the questions that was raised during our June board meeting. And that is, since then we've also engaged with the IESBA, and that is included in the paper. And we also then invite Rich to give that practitioner's practical view of how the extant code is currently being applied. The last one is the focus on pension funds. We do recognize in our paper that there are similarities, but we do know there is some significant differences between pension funds and collective investment vehicles. We will come back in Q4 and focus a little bit more on pension funds. The same approach, desktop research and questionnaires and interviews has been done for pension funds as well. It not come through the paper so significantly, and we will address any matters in that regard in future as well. Just a quick recap just on findings to date, just before I set the scene, or to set the scene. The investment scheme industry is diverse. we hear that there is various structures, there is different kind of funds. You have the mutual funds, you have the unit trusts, the vanilla funds as we call them, but you have different structures as well. John will speak a little bit to those. We found that some jurisdictions have unique structures that's not always available or kind of known to other jurisdictions, and that kind of adds a different dynamic. During the June meeting, we spoke about the legal frameworks. We explained how these are constructed, whether they are contractual or whether they're corporate. We found that even though they in two jurisdictions might have similar in corporate structures, their functions and how they interact and their responsibilities can differ significantly. So you can't say if it's a corporate structure, this is the rule, or whether it's just a contractual, that's the rule. So there is so many differences jurisdictional wise as well. And then also what we've seen, that control, that also we defined during the June meeting. John spoke about how control is being defined in different jurisdictions as well. This is a highly regulated industry. We've heard from many stakeholders noting that different parties are being regulated, requiring certain requirements and sense whether the investor should be registered, how they are monitored, and whether custodian should be independent of the investment advisor. I know I'm showing a lot of the parties' name, but this is kind of just showing that there are, recognizing that it is regulated, but an additional layer is that where the auditor actually is in as well. The auditor's independence is key in this regard as well. Regulatory obligation on third parties to have the fiduciary right. They're not acting on their own behalf, they're acting on the interest of that of the investors, we've heard as well. So these are the things that we've been taking into account as we've developed the paper and what we will be presenting to you today. With that, I would like to hand over to Rich. That will then go into the next section of the presentation to explain the practitioners, the practical application of the extent code.
Thank you very much. Just to provide a little bit about the objective in this section is we'd like to provide a review of the application of the extant code on the assessment of related entities for funds or CIVs. And you will hear me use the words funds as I talk through this. And the idea is to provide a baseline background on the current state for the discussion that will follow and the presentation the project team will take the board throughout the rest of the presentation. And then at the end, we will have a slide to go over a high-level overview of the US SEC investment company complex as it's presented in US Regulation SX 201. This presentation, my presentation, represents solely my views based on the extant code in the 2024 handbook and as reviewed by the team. So let's move to the next slide. This first and foremost, we all recognize that the auditor needs to be independent of the audit client, and the code, as you can see on the right side, has a definition of how you determine what the audit client is. And for publicly traded entities, or PTEs, the audit client includes all related entities as related entities are defined in the extant code. And for a non-PTE, related parties include those entities over which the client has the direct or indirect control, and thus does not involve any entities that might be parent or sister entities, or what we might refer to as upstream entities for non-PTs. These principles, and this is an important point, on the definition of audit client and related entities are applied to all entities under the code, under the extant code, and not just funds. And that's an important point to keep in mind. As we move to the next slide, the current application, the first question is the fund a publicly traded entity? And the definition on the right defines a publicly traded entity as it was developed under the public interest entity standard. And it has a key element that says the entity issues financial instruments that are transferable and traded through a publicly available mechanism it would be a PTE. That includes listed entities, but it goes beyond listed entities. And thus, if you are if your client or the fund is a publicly traded entity, then you have to consider those upstream entities. The three prongs are listed here on the slide. These are entities that these are entities which they have control over the fund, or a material significant influence, and or our sister entities. It is important to note that all three of those prongs do have materiality considerations in them, as it is in the extant code, and we'll come back to that. Excuse me, we'll come back to that in a little bit. But also, it's important to remember, if you're not a PTE, then these three prongs, the entities that might be in those, are not related parties under the code. So let's move to the next slide, please. So again, this is it's kind of a step sideways for a second. Historically, and in fact, as it is today, only listed entities have to consider whether all related entities are, or all entities under all the prongs are related entities. The changes made by the public interest entity standard to introduce the concept of a publicly traded entity will go effective on 15 December 2024. And there are certainly funds today that are not listed entities, but are publicly traded entities. And so thus there will be an expansion in the number of funds which the audit client definition will now include the need to evaluate the upstream entities, those parents or sister entities, to determine if such entities are part of the audit client. The extent of this impact is not, cannot be predicted at this time. It's not known how many entities this will involve, how many more entities will become related entities. But that is something that I think it will be important to understand as time passes and we get some experience under the new PI standards. We can move to the next slide then. So in this scenario we're looking at, we've determined the entity is a PI. And so the first prong, as you saw in the earlier slide, is then, is there an entity that controls the fund, and is that fund material to the controlling entity? And as has been discussed in prior board meetings, and in the board paper for today's presentation, and as you'll hear later in this presentation from the project team, there are many different types of funds, fund structures, legal status of the entities, and other variables that are all relevant to the analysis, such that there's just such a wide variety of solutions that you really have to focus on what are the facts and circumstances related to the individual fund entity being audited as you make the assessment around control. Control can obviously exist, as we well understand, based on voting rights, board seats, or potentially by contract. And generally, the consideration is, does an entity have decision-making for the fund? Decision-making includes, for example, the ability to direct or indirect, includes the ability, whether it's direct or indirect, or the power to direct or cause the direction of the management, the policies, and the activities of the fund or a person or entity, which includes decisions related to retaining, and those can include decisions related to retaining or changing third-party service providers that might include the investment advisors, custodians, and record keepers. So again, if an entity, is there a party that has more than 50% of the voting shares, has more than 50% of the board seats, or through contractual rights can make those decisions that most impact the activities and the policies of the fund. In general, today, the independence assessment follows the accounting determinations. And when the accounting determination is to consolidate based on control, the independence conclusions will follow that accounting validation, or excuse me, conclusion. That conclusion that is based on both the IFRS standards and the FASB standards, which are substantially the same in terms of determining control. However, it is possible that the accounting determination is not to consolidate, but that the independence conclusion might conclude that control exists. And an example of that is under the accounting standards, there are situations where the party controls something, but does not reflect that in the consolidated financial statements, but just reflects their interest in it, such as what almost all funds follow that accounting. And then again today, entities that are contracted to provide services such as recording of transactions and drafting of financial statements and other processing activities are typically not decision makers. And then the second thing to keep in mind on this slide, it's very important. You can have situations where there is an entity you've determined that has control over the fund to be audited. However, you also, in the second part of the test in the existing code, need to consider materiality. And that's usually based on an investment test and an income test. And there are, in fact, entities that control a fund, but the fund is not material to those entities. And thus, the control entity is not a related party under the extant code. And by the way, this is true not just of funds, but it's true of any evaluation of parent entities or controlling entities. So before we move on, I'm going to mention, we're not going to go through the same analysis for material significant influence or common control because the concepts are the same. The thresholds are just different. Material significant influence, obviously, at the 20% level, and common control at the dual materiality standards. But the point was to illustrate how one thinks about control and also how the fact that materiality is a factor in each of the prongs under the existing related party evaluation. If we can move to the next slide. There we go. This also points out some other considerations from the extant code. It reminds us that any auditor needs to consider the application of the conceptual framework from section 120 as reiterated in 300.4, and also the application of the reasonable informed third party test in 400.5. And thus, auditors will consider whether there are interest relationships or services or result in a threat to the fundamental principles or their independence, even in some cases, well, including when there are not related entities. And the most common time can be seen is that when you are auditing a fund, there are systems and processes and controls related to those that exist at other entities. And as part of the audit, you have to understand those. The auditing standards call for you to do a walkthrough and understand those controls and design appropriate testing under that. And in those situations, if a firm as an auditor determines that it was involved in, or its network was involved in the design, build, or implementation of a system that an entity uses to process or record activities of the fund, they have to assess whether that results in a self-review threat and whether there are safeguards that reduce that threat to an acceptable level. Building on that, if we go to the next slide, as I indicated, there are commonly third-party service providers involved with funds. And as the auditor, as I indicated, those service providers process activity and transactions that it is important to have a basis of understanding about the effectiveness of those controls. And so frequently the auditor is not the auditor of those service providers. And so in addressing that, addressing whether they have design and operating effectiveness over the controls, service auditor control reports are obtained to address those controls over the processes and the recording of activity. Remember that service organization control reports do require independence of that service auditor, providing that opinion for the service organization. And thus, the auditor of the fund is not the party testing those controls, but rather it is another professional or PA that is doing those testing. And that is, as we recognize on the extant code in both section 300 and 400, something that the code recognizes as something that reduces threats is to have another party performing those procedures. If we could go to the next slide. This just lists some common circumstances in the marketplace. It doesn't list all of them, but we thought we'd put this in talking with the project team to help set some of the framework of what the current environment is. First, it's not common that an auditor or a fund will require services from another party. And so it's not services that of the nature that a professional services firm would provide. And so it's not common that an auditor is providing directly to the fund a service beyond the audit. And in some cases, there are a need for some tax compliance that relates to demonstrating that the fund qualifies under the local jurisdictional flow-through rules such that there is not double taxation. Secondly, there are some funds that are not able to contract for services because of the legal status of the entities, and thus a decision maker, which is often a board of trustees or board of directors, is the one who actually engages third parties and the auditors and enters into whatever contracts need to be entered into. And then in some jurisdictions, it's common that the fund and the fund manager are all part of a group that are all audited by the same auditor. And thus, in those cases, the auditor of the fund is also independent of what we refer to as the manager, which is often an advisor. At the same time, there are jurisdictions where regulation require that the auditor of the manager or advisor be different from the auditor of the fund. And so that goes back to the point I made at the beginning and what you've heard from the project team over time is just the variety of circumstances that contribute to this being a relatively complex area. So with that, if we could move to the next slide, we're going to shift from talking about the application of considering who is the audit client and the related entities under extant code, and just provide an overview of the investment company complex under the SEC regulations. Now, it's one thing I would point out here, not right or wrong, but the ICC is what is often referred to as a rules-based approach, in contrast to the code, which we clearly, as we understand, is a principles-based approach. And it is a unique prong to the determination of affiliates under the SEC regulations. So it only applies to the entities that are subject to the investment company complex. The other rules that determine affiliates for other kinds of entities are in different prongs. It was amended in 2020, as was other parts of the determination of affiliates, to better align the SEC framework with the IESBA framework, in particular in the use of the dual materiality test for common control. And there were some revisions as part of that to the ICC in terms of the scope. The entities that are subject to this are registered investment advisors, registered investment companies or funds, and then in 2020, it was expanded to include investment advisors that are subject to what is referred to as the custody affiliate rules under the Investment Company Act in 1940. And that expanded the ability to use and the application of the ICC to virtually a much larger section of funds, including some that are not themselves registered entities. So with that, I'm going to walk you through the bullet points. Besides the fund entity under audit, the following entities are affiliates. And for purposes of this discussion, I should have mentioned this earlier. The concept of affiliates is the same as the IESBA code concept of related entities from that standpoint, and that in terms of determining the definition of an audit client. So the fund itself that's being audited and the advisor to the fund entity under audit are always in the ICC. And they actually use the phrase investment advisor or sponsor. Those often are one and the same, but not always. And sponsor is a very uniquely defined term in the federal securities law. But again, think of it as the party, whoever the entity is that's doing the advising to the fund. And then it also includes entities that are under common control with the fund entity or the advisor to the fund entity if they provide administrative, custodial, underwriting, or transfer agent services to the fund entity under audit. So it's important to note that not all third-party service providers that perform those services are related entities. It's only those that are under common control of the fund and the fund and the advisor to the fund. And that recognizes that those similar to the comment I made on the extent code, that recognizes that when they're third parties, those administrators, custodians, transferred agents, people who bookkeep and draft financials are usually not decision makers. In addition, all funds managed by the advisor of the fund entity, regardless of the materiality, are also affiliates of the fund under audit. And then this next bullet identifies entities that have control or material significant influence over the fund. So these are the upstream investors in the fund, and those are typically where you scope in general partners or managing members of a LLC. The next prong then addresses the downstream entities, which is very much identical to the extant code. It is any entity that's controlled by the fund entity under audit or over which the fund entity has material significant influence. And then there's a bucket at the bottom that we've summarized here is these are other entities that are under common control with the fund entity under audit, the advisor to the fund entity audit, that meet the dual materiality test, including certain subsidiaries and controlled entities of the advisor or a sister fund managed by the advisor. There are some complexities to this, but in general, it's designed only to scope in entities under common control that meet the dual materiality test. And that was one of the revisions to ICC that further refined and reduced the number of entities that might be captured. So John and Joan, I pause there and turn it back to you.
Thank you, Rich, and yeah, thank you for your time for the presentation. So we just wanted to open up for the board for any questions or comments.
Hi, thank you, Rich. I just wanted to make sure I was at common understanding on slide 10. We had a bullet point that entities are contracted to provide services, including are typically not decision makers. In my experience, I've never found one that was a decision maker. So when I see typically, sometimes that could mean a variety of ranges. I just wanted to make sure that your range of outcome is pretty much the same or different than mine, if you could.
Well, that's an excellent question, Andy, and an excellent point. The reason I said typically is sometimes some of those activities are part of a manager entity that does in fact control. But in general, as you said, it's very, particularly in most jurisdictions, it's very rare that someone who is just contracted to perform and execute specific tasks that are defined for them by contract, such as the party who bookkeeps the transactions and drafts the financials, they don't have authority or decisions over what transactions get executed, for example, and thus are not a decision maker. I hope that conforms with what you were asking, Andy.
Yeah, that's the same experience that I have. I guess I never say never, but I don't believe I recall any where the decisions were made.
Yep. Agreed.
Thank you, Rich and Ade. John.
Yes, sorry, Rich, actually just an extension on Andy's question. So when you talk about a management entity, so we've seen examples where there is that management entity, but there is still a board, for example, but the management entity is making all the sort of day-to-day decisions for the operations, the investments, that sort of thing. Is that where you would consider that management entity to be a decision maker, or is it still the board or the trustee that's the decision maker? Just to clarify if there's some sort of line, a bright line.
Yeah, I think a lot of that depends on the contractual terms that exist and the relationships between all the parties. I would say where we see those manager entities, they may have control, but it's also pretty common that even though they have control, the funds are not individually material to the manager. And so they're not a related entity, John.
Thanks, Rich.
Thank you. Any other questions or comments on this first part of the presentation? Okay, seems pretty clear. Rich, back to you.
I think it's actually back to John. I don't have any further.
Okay. So again, thank you, Rich. Again, and we met with Rich a few times, and he invested a lot of time with us to discuss some of the issues. So we really appreciate your input, Rich. So firstly, I did want to, if you want to go to the next slide. Oh, sorry, you didn't realize you passed. Sorry about that. Okay, so firstly, I just wanted to reflect on Rich's presentation and then how this sort of interrelates to what the project team has been researching, some of the things that we've found and some of the perspectives that we've indicated as well. So as Rich said, when the third party to a CIV is a related entity, and as Rich mentioned, it's not a very common thing from what we've gathered, that it is considered to be a related entity under the code provisions. And as Rich said, that it may not be material as well. So we've been focusing on the entities that sort of operate the funds. And so in our view, they're decision makers, but they're decision makers in a day-to-day sense in terms of the activities of the fund on a day-to-day context. And we haven't been really focusing on those ones that Rich talked about, where they're providing minor services like recording transactions or drafting financial statements, that sort of thing. So we've been more focused on those entities that are maintaining the sort of the day-to-day management. So when Rich mentioned around the decision making for the scheme, we haven't seen, as in a general sense, that day-to-day management as a factor that's used when to determine whether an entity is related entity or not. Also relating to the current practice that Rich mentioned around the application of the conceptual framework, and when that says when a third party is not related, so an unrelated third party. So this has really been the focus of the project team, and where we want to ensure that there is that consistent approach to relevant interests, relationships, and circumstances from an independence perspective. We'd also, as you could see from what Rich talked about, the ICC rules, and as John mentioned, that was part of our mandate and the objectives of the project team is to consider those investment company complex rules, and in terms of how they would potentially relate to the code or whether there's aspects that are relevant for the code. Our view is that they're overly complex, especially from a global code perspective, and they do bring in a number of specific aspects that are relevant to the US context. So we do see them as overly complex, but there are certain aspects of the rules that we think are worth exploring from the IESBA code perspective, mainly in respect of focusing or segregating any potential provisions that might come about. And this goes back to Andy's point from the last meeting, actually, around trying to avoid, transcending other entity types, that sort of thing. So there are certain aspects of the ICC rules that we see could be quite useful. The other thing is, yes, we've obviously seen that the CIVs take on different legal structures, but they also have different investments. Predominantly, these are corporate structures, unit trusts, or contractual arrangements. I'm going to go through in a little while a little bit more in greater detail about what these different structures mean later in the presentation. But the schemes also vary in what they invest in. So more commonly, the schemes are mutual funds and they have more straightforward investments. However, we have seen schemes that have higher risk elements or higher risk investments. So, for example, we've seen these alternative investment funds. Whilst these are generally or more commonly made available to sophisticated investors, so those that are with more capital, more sophistication, but stakeholders have advised us that this is not exclusively the case, and they can be available to retail investors in some instances as well. And if you'll bear with me, I do have a couple of Australian examples because I know a little bit more about the Australian environment. But in terms of these sort of more riskier investments, so Australia had a number of big collapses in what's called agricultural schemes. This was around about 10 years ago. There was one called Guns Limited, another one Timber Corp, another one called Great Southern. And this actually resulted in billions of dollars of lost funds, and a lot of that actually related to retail investors. And there's been a number of inquiries into the Australian environment, and one of those talked about, or there was recommendations to ensure that those schemes could demonstrate they had sufficient working capital to meet obligations, to avoid ending up being some sort of Ponzi scheme where later investments are propping up previous investments. So why is that relevant? What's the point? I guess the point is, from our perspective, where there are funds that are riskier, we believe that the auditors, the professional skepticism and also the associated independence becomes more prominent and more important. Because what we've actually found is that some stakeholders have almost downplayed the auditor independence to some aspect, because they talk about there's a lot of regulation, a lot of different rules, all that sort of thing, that it's like, oh, maybe it's not as important. We don't agree with that personally. As a project team, we think it is still really important, and in particular where there are riskier investments, that really does come into play as well. In saying that, we do want to get a greater understanding of these other types of investments, just to get a bit of a greater understanding of the magnitude of how that impacts retail investors and into those higher risk schemes. So this slide sort of provides a high-level overview of the governance and oversight of CIVs. So there are potential conflicts of interest between the CIV third party, so in other words, the one that's operating the CIV, and the CIV investors. So there's an IESBA report which is on the principles of valuations of CIVs, and that noted that the management of conflicts of interest is critical in ensuring that CIV assets are valued appropriately to protect CIV investors, and provides a number of examples of how those conflicts of interest could arise. So I'll just run through a couple of those. So first of all, the operator of the CIV could overvalue CIV assets to attract more investors by showing an inflated performance record, therefore earning more management fees. Another example is the operator of the CIV could dump unattractive assets into a CIV at an overvalued price. And another example they provided in that report was the operator of the CIV could undervalue the CIV assets and cause the CIV to sell them to affiliates at an artificially low price. So there's just some examples of where there definitely could be conflicts of interest between the operator of a scheme and the CIV investors. And as I mentioned, or as Jean mentioned as well, that stakeholders have invariably referred to the highly regulated environment and the fiduciary duties that these third parties to the CIVs are subject to, and in particular, the duty to act in the best interest of the CIV investors. In fact, one of the reasons that we've been told from stakeholders for why a third party to a CIV does not control the CIV is that and is therefore not a related entity from what Rich went through. It's because that operator does not act on its own behalf, but on behalf of the fund and its investors. So we're talking about this best interest duties here, but there is evidence to suggest that the best interest duties by itself is not always going to protect investors. So another Australian example, so I apologise for that, but there was recently a Royal Commission in Australia into the misconduct into banking, superannuation and financial services industry. And amongst other things, it found significant misconduct in relation to conflicted remuneration, including things like fees for no service. There was fees being paid, charged to dead customers, for example, but also a number of things around breaches of the best interest duties. And this resulted in the banks in Australia having to repay customers billions of dollars. I can't remember the final amount, it was about $5 billion, I think it was, that they had to repay to the investors. And a lot of that did relate to breaches of the best interest duties. So CIV arrangements include various measures, therefore, to protect the investors, and including to ensure that the CIV operator works in the best interest of investors. And again, another IESBA report looked at the examination of governance for collective investment schemes. And it noted that CIV oversight arrangements provide independent entities with the appropriate legal conditions and autonomy to exercise their powers and functions without interference from the CIV operator. So again, it's that independence, but from the operator. So the independent entities that they refer to are the trustees, or like it might be independent trustees, independent directors. There's also regulators, but also auditors as well. So the project team believe that auditors of CIVs provide an important additional layer of independence to protect CI investors' interests. So this flowchart was part of the agenda papers and the agenda items, and it sort of highlights where the project teams think there is a potential gap in the code that we think the board needs to consider. We have made some minor tweaks to what was in the board paper, and I'll explain that as we go through. So the first box on the top left, that sort of highlights the public interest element of that relates to investment schemes. So they're accepting money from the general public, and there's obviously an importance in protecting the investors' interest in those schemes. So the OECD defines CIVs as pools of assets in which investors share in the results of a specific portfolio, but they do note there's legal differences in the legal forms of the CIVs around the world. So the general public, so they invest into the CIVs, they can be done directly, but the other aspect is that there is indirect investment into collective investment vehicles through pension funds to support people's retirement. John, later on in the presentation, will give some statistics around the levels of investment, which reflects the public interest that relates to CIVs. So then we go to the large box on the left. This highlights that the project team's focus is on those entities that undertake significant activities in respect to the scheme. So, for example, that they might effectively operate the scheme, or they might be the decision maker on a day-to-day basis. So not from what Rich was talking about, we're talking about the day-to-day decisions of the scheme. What I was talking about where we made some amendments, the agenda paper referred to where maybe that third party is undertaking significant management responsibilities on behalf of the scheme, or maybe they're in a position to exert significant influence of the scheme's financial statements. In terms of, some advanced comments, we did receive some advanced comments around that maybe these tests are not the best things to focus on in terms of capturing the specific issue and principle that we're looking at. So on reflection, we think that the overarching principle should be that auditors of schemes should be independent of those that determine the success or failure of the scheme and or materially affect the performance of the scheme. So, and looking at this from the perspective of interests and relationships and circumstances from an independence perspective. So again, we're not trying to focus on parties that are not contracted to provide like minor services, like Rich has mentioned, like recording transactions, drafting financial statements. We're really talking about the management of the company, that day-to-day activity, the investment decisions, the control of assets, all those sort of the custody of assets, those sort of aspects. So then if we move down, if the third party is a related entity, then as we've seen with what Rich presented, then the code acts as per normal, and if the third party is considered appropriately through the independence provision. So if the entity is not a related entity, or if that materiality doesn't exist, which Rich mentioned, this is where the project team believes there's a risk that the independence might not be adequately assessed. So this is because reaching the right conclusions by applying the conceptual framework requires a comprehensive and nuanced interpretation of the code and its interrelated provisions, the exercise of professional judgment, and the use of the reasonable informed third-party tests. And also it means that all of the relevant interest, relationship, circumstances are taken into consideration as well from that independence assessment. So as a project team, we believe that greater clarity could be included in the code to signpost and ensure that unrelated third parties to a collective investment vehicle that undertake those significant activities for the CIV, they're operating the CIV, or they're a decision maker for the scheme, that they should be included within those independence assessments. I was going to pass over to Richard, because he also had a sort of different, same perspective, but from a different angle in relation to this, and then we'll go to the board.
Apologies. The point I wanted to draw out, there are 2 points I'd like to draw out, if I may. And the first is that what's in the red box as being the gap in the code that we think should be explored and checked and explored arises from what's in the large box on the left-hand side, namely that the third party has significant influence over the scheme or the fund. And that is mirrored in the extra provision in the ICC provisions, which Rich focused on. And if we could just go back to that slide just quickly, John, you will see 3 up from the bottom, any entity that has control, forget control, or material significant influence over the fund entity under audit. Now, because significant influence isn't a criteria for a related party under the code, that circumstance does not get caught by the code and bring us within the regime that exists. Go back to the flow chart, please, John. That is set out in the flow chart, because it doesn't tick the box of the small box above the red and result in the third party being regarded as a related entity. If it isn't regarded as a related entity, there is no requirement under the code to then consider the independence of that entity and whether or not the auditors of the audit of the scheme are independent of the entity that has the significant influence. And there are certain circumstances in which that could be relevant. Personal relationships, financial involvement, business activities, relationships, and so on. And the concern is that if we're not looking at that and determining whether or not there's an independence, the audit firm is independent of that third party, then we have an exposure under the code. Now, it's clearly a narrow, if I may put it this way, narrow point, but it's one which, if it goes wrong, could have significant consequences. The other point second point I wanted to make at this stage is that it's important in considering this whole issue of fund structures to remember that we're only concerned with the ethical consequences of the situation. We're not concerned with the audit consequences. And I just want to reiterate that, because it's terribly easy to start thinking in terms of the consequences of the fact that X is managing the fund. That's not what this is about. That's for IESB and ISAs to deal with, and they'll deal with it as they consider appropriate. And for us, the question is whether or not there are ethical considerations that arise out of the closeness of that relationship and the influence that that relationship has on the fund itself. And I hope that that just brings out two things: the contrast between audit implications and ethical implications, and secondly, brings out the fact that this, what we have identified as being a gap, is actually consistent with an element of the ICC definition, which they've then addressed through the SEC regulation. Jan.
Okay, thanks, Richard. We'll go to the board for their comments. So we just wanted to ask the board's views on whether they agree with the project team's analysis that there is a gap in the code regarding the auditor's evaluation of auditors' independence from investment schemes with respect to interest relationships or circumstances involving the auditor with the unrelated third parties, e.g. investment advisors, fund managers and sponsors. So just an important point there is that we're focusing here on interest relationships or circumstances. We're not necessarily saying in full independence from the entity, but around those interest relationships or circumstances. So I'll pass this to you, Gabriel.
This is the issue which we think needs to be explored.
Yes.
Thank you very much, John and Richard. And let's hear from the board if they agree with the conclusion that you reached. David, please.
Thank you. I think the way you've laid it out is actually really quite clear in terms of where the gap is, which is great because I know it was a question on a topic we talked about a couple of board meetings ago now. One question for you, and forgive me, it seems like a simplistic question, but it helped me put things in context. Is it really as simple as it's a gap in the related party definition? Is that uniquely where it sits in terms of the independence issue or the potential conflict of interest, right? Because that's what we're talking about here. Is it uniquely that, or is what you're saying that's potentially the best area to address that? So I'm just trying to get some sense of, is it really that narrow a problem, or is it more that about the remedy?
Well, we're saying that the related entity is not capturing these entities, as from which we're accepting those sort of extreme circumstances. It's not capturing those entities. We're not necessarily saying that's the best way to address it, because impacting the related entity in all those definitions is going to cause potentially a lot of unintended consequences. So there are other ways to address it, which we need to explore further. We started looking at some of those in the last board meeting, but we want to look further into those. But we want to get the board's views on, first of all, whether they think there is a gap. But we think there are ways of isolating the issue and focusing on. And so just as an example, we did bring out, for example, there's a signpost that was put in around, say, indirect services related to technology. So that's an example of where it's a signpost to say, for these types of scenarios, you need to apply these provisions. So it's not necessarily about changing the related entity or those control functions, that sort of thing. It's just about these specific issues that relate to these types of funds.
So I think that's really helpful. Thank you. And I might be preemptive, and feel free to tell me that if that's the case. I know we're going to come back to pensions in the fourth quarter or the next board meeting. In terms of just preliminary thoughts, are you seeing the same type of challenge? Is it a related party definitional issue as your early findings? Granted, I'm not asking you for a definitive answer, but just give me some sense, if you could, please.
So there are aspects that are similar, but it is not to the same extent, because pension funds are not generally open to the public. So you'll have like an employer-sponsored fund, for example. There are in Australia, another Australian example, but there are specific funds that are open to the general public, and you can choose to go into those funds, and you can also set up your own fund, all that sort of thing. So there are examples where it is quite similar. It is a similar type of structure. There's still someone that's a trustee and a manager, all that sort of thing. But there are also a lot of differences, and we don't want to say that it's the same, because it's not. Sorry, Richard, did you want to add?
Hot top.
I'm very inefficient. David, I think that it's important to emphasize that through the next phase, assuming the board approves the next phase, it's going to be important to understand and explore the nuances and detail of some of these, the gap, and how it applies to different relationships. And that may influence how one then decides to respond through the code. I wouldn't necessarily say that I'd be uncomfortable if the board went away with the idea that we've identified the gap, we plug the gap, that's the end of the job. I think there's more to be done to understand the different types of relationships that give rise to significant influence over a fund or a pension fund, and therefore how those should be addressed. It may be that there are differences in how the particular risk that one identifies needs to be addressed. That's the qualification I'd like to leave on the table, because I'm not sure that until we had the consultation processes and got people coming back to us again to respond to the gap we've identified, that we will understand all the nuances of it.
That's very helpful. Thank you. That's great.
Thank you very much. It's interesting that you are all. Are you coordinated? Is this a task force? Yeah, but I think that the next one was Paul, who raised the West.
Okay, thank you. I think that is going to that closing point. This is a lot about nuances and detail on how it applies. And just to understand from your engagement with the cross-section of the types of funds and entities you were talking to, were they kind of embracing this as an issue of a perception risk or an actual risk in terms of how they conduct themselves? And how do you balance, even in terms of the cost and complications that can come into trying to unpack all these layers, if it's just a perception management issue rather than a real management issue? Just love your thoughts. Thanks.
So on that point, so what we have seen is a number of jurisdictions have made direct changes to legislation. So the US is a prime example, but there are certain other jurisdictions we've looked at where they have made specific legislative changes to address the issue. That's not across the board, but there are definitely examples of that. So it's more than a perceived risk. They have seen that there is clearly a risk, and they've gone to a point to address it. So in some aspects, we believe as a project team that we're sort of below the curve in that sense. But obviously from a global perspective, it is a difficult thing to address. But that's why we're saying we need to sort of establish what is the actual principle that we're trying to apply. What is it that they're doing that when it gets over that's a tipping point, or where below it's not. So that's why we, for example, we've changed that aspect in the slide, and we need to sort of clarify that more in terms of where that tipping point is.
Okay, thank you. Amajit?
I came later, but okay.
I'm sorry, I don't know who came after, but you almost, okay, let's.
Shall I? Okay. No, so some of what I wanted to say has already been said by Paul and David. So I like this work, just to begin my comments, because, you're trying to address an area where there's a lot of public interest involved, and I think not enough work has been done globally to understand what the risks are and how those can be addressed. I just have a couple of suggestions. One is that I believe you've done some survey of various jurisdictions, and if you can do a little deeper dive into those surveys and also see it from what are the risks which are there in different jurisdictions. So can we bring those risks to the table? A little sharper identification of the risk, and not just the US model. I would say compare the code with other important markets as well, and perhaps we may come up with more than what we have as of now in terms of identification of the problem we are trying to solve.
Thanks so much. And perhaps later on, you will see that's where we want to head. So.
Okay, Sadia.
Thank you to the presentations. I think getting it in context and getting examples of countries allows us to understand it better. I think the working group has done a good job in showing us where the gap is. But we need to also just pause and see how much of the gap needs to be plugged. And I would emphasize we're dealing with jurisdictional, lots of complexity. And if we're learning anything from sustainability, that capturing what we're trying to do is going to be as hard as actually doing it. So I like the direction of travel. I just want to emphasize we don't have to fill the entire gap because we do have a conceptual framework as well.
Thank you, Andy.
Like dominoes coming down. No, thank you for the presentation, and the context is really helpful. And I'm not going to open the topic of accounting and evidence, Richard, but I do have to put it in context in my remarks, in that when I hear of unrelated third parties, I am thinking as an auditor, I'm getting evidence from an unrelated third party. That's an arm's length sort of transaction, and it's kind of a wholly objective place to go to. But if what you're uncovering here is that those are not really unrelated third parties, they're the decision makers or intimates of the company, then I think you have discovered perhaps something that is not subject to just ticking and tying. I don't mean that in a meaning way, but you need to have if you have the intimacy with that information, then it's part of it's part of the management sphere, and therefore it has to be looked at different from an ethical perspective, because my client is bigger. So I am skeptical that what previously called unrelated third parties are making decisions and they are undertaking management obligations. But I would say if they are, then I think that this is a gap that needs to be filled. So I guess what you have me saying is I want to learn more to understand that, because if they are making decisions, as opposed to executing transactions, keeping records, doing very important things that if they screwed up would be a big problem, but still they're doing it as a third party, not as an intimate member of management or of management responsibilities, then I definitely want to keep going with the exploration.
That is the heart.
Okay, cool.
Thank you, Andy. Luigi.
Yeah, thank you. Frankly, I do not understand whether this is really a gap or it is a perception of a gap, as already has been mentioned. Because if we apply correctly, even a PA apply correctly the conceptual framework, any interest, relationship, and circumstance with any third party which are relevant on the independence of the collective investment fund would be considered. And there is no need, I think, to extend the independence to a third-party entity, while the issue is really whether there are such interest, circumstances, and relationship that could affect. So I think that it could be a gap, but it could also be a perception of a gap. And I don't think you provided so far, let's say, you find in your analysis so far convincing evidence that the code today, if applied correctly, will not address this matter. If it is not applied correctly, it is another story. Another thing is, sometime you referred during your presentation about the fact that these third-party entities with certain condition need to be included into the assessment. I am not sure that this is the real, the correct way to address this matter. It is not an issue of third party being involved, but it is an issue of interest, relationship, and circumstances that could affect on the independence of the auditor or the fund auditor that should be assessed, and therefore, let's say, everything should be developed under this way. I'm not saying that I will not arrive at the same conclusion, but probably the starting point is different. I would not think that just extending the definition of related entity would solve the matter, because if really the perceived gap is a real gap, this is simply, let's say, an extension that will not address all cases. While if you address this concept of impact on the auditor independence, which is not linked simply to the rule of extending, let's say, the definition of the related entity to certain entity, if you focus on this matter, probably you are more complete in the analysis. Another thing that I would be very interested in understanding is that some real life example of where a failure of the fund was linked to the auditor independence with respect to the third party entities, because the example we received so far are relating to failure of funds for other reasons, because there were relationship between the fund and other entities, but the auditors was not involved. And in any case, the independence was not involved. So the gap was not there, or at least it is still in a phase of perceived gap. So I think that further analysis is needed, in my view, and probably a more in-depth analysis with respect to those countries that are leader in this industry, where there are a massive amount of these type of schemes, because probably they also have more experience than others.
Thank you, Luigi. We'll take those comments on board. And there are just a couple of quick responses. So I totally agree with the conceptual framework. We're not saying you necessarily wouldn't get to the same place, but we still feel that there is a risk that you might not. And I guess if that's the case, like there's a lot, pretty much all the part 4A is essentially the application of the conceptual framework to come at what the board decided is the right decision in terms of those particular circumstances. But I also agree the focus is not necessarily on the entity. It's more on those circumstances, interests, relationships, and the impact on the audit. And that's why we're saying we need to develop what's the principle in terms of what that is. So we need to do more work on that, and further analysis is needed. But appreciate your comments, and we'll look into those. Thank you.
Thank you, John.
Oh, sorry, one other thing with the failure. Yes, we haven't identified a specific failure relating to lack of auditor independence, but we think it's important that the board gets ahead of the curve to prevent, to be there before anything such as that does happen. So thank you.
Sorry. I agree with this consideration. The only issue is that I got the impression that you started from the failure and then you arrive at the gap. I think there is a missing element there, whether, let's say, the gap was due, let's say this failure was due to the gap, or this failure was due to other things. And I think that the example you presented to us was for another reason.
Okay, thank you. Laurie, please.
Yeah, thank you. And this is really a fascinating topic, and I think you guys have done quite a bit of work since we spoke before. In a certain sense, some of what other people have said was on my mind as I was reading. My thought process was sort of, are we to avoid what I would call edge cases and gymnastics to look at things. This is a bit, for me, a cost benefit. Ultimately, we're still at the exploratory stage. I understand that. And obviously, I think we need to hear a lot more. But I think in terms of the definition of related parties, that concerned me a little if we go too far down that route. Not to say that there couldn't be a reason, but I think we just need to be careful and make sure that there's a benefit for the complexity that we might be adding at this particular time. I can't really say much else more other than, is there a need for this? Is there a compelling reason to be doing this? I think it's still too early to tell that. My sense is that's where you want to go to figure out, the underlying bit. Okay. Well, I think it's progress, so I think that's excellent, and I'm certainly learning.
Thank you, Chair, and thank you, hard work, for this exercise. If, as Richard said, the third bullet point from the bottom, the entity in that ICC rule is might be missed in the as a related entities in the code. I think that's very critical. But the following explanation, it didn't convince me that that is missing from the code. So that's why I need more clarification how it can be missed. But the interesting part was that about that agriculture schemes where there might have been fraud. So I wonder that like those Ponzi schemes in the past, whether those were not identified by the auditor because of any independent issue, then such kind of examples may help me to understand what is missing in the code. But again, still not I'm convinced that what is missing in the gap critically. Thank you.
Thank you, Tomoyo. Amajit.
Yeah, just a reaction to a couple of comments which have been made, mainly Duji's comments. So I think I completely agree that there is a need for sharper analysis of the gaps. No questions about that. But one counterpoint, we need not wait for a market failure to happen. So then we get into the action. I agree, maybe there is no market failure as of now. We don't see any big example where a collective investment scheme failed because of auditor related issues. But should we wait for that to happen? Perhaps not. So we can probably get proactive and see if there are gaps and then try and address those.
Sorry, may I clarify my, probably I was not able to explain my process, the process I followed. I'm not saying stop everything until when we have a failure. Not saying that.
I didn't think.
I was saying another thing, say we started from the certain failure and they ended to the gap. What I'm saying is that I do not see any connection between the example and the gap. Only that.
Right.
I would change my mind if this connection was found or will be found in the analysis. But having said that, I would not say, well, wait until when we have a big issue.
Yeah, got
This
it.
is not my position.
Right.
So just to clarify, with the example, I don't have evidence to say that it was due to auditor or lack of auditor independence. But what I was trying to, I guess, just demonstrate the risks that can be involved in these types of schemes, especially if there is a conflict of interest between the operator and and that they can be quite huge and catastrophic for investors. So it wasn't to highlight that in this particular example there was auditor independence that was lost, but there are potential, and that the auditor is another layer and a very important layer in that aspect in terms of ensuring that investors' interests are protected. So yeah, just want to clarify that point.
Thank you, John. Rich, please.
Thank you. Let me start by saying I am sympathetic to the challenge the project team has been given with this project, because I frankly don't think we had a very clear reason why this even needed to be a project. And I'm not sure we have the gaps here perfectly laid out. I'm going to make some specific comments that maybe build on. I'm not saying to stop. I'm just saying I think we need to be more thoughtful about what the focus is. First, I have to reiterate, I think we need to be cautious about suggesting that the scandals and the potential magnitude of issues from those kinds of events are a basis for this, because in the current environment and for decades, there are tens of thousands of CIVs, maybe more than 100,000 around the world. When you throw in some of the other things that John and the team have identified, and it's not just that we've had some edge cases. I don't think we've found any cases where auditor independence is relevant. That doesn't mean there isn't a gap, but I'm just cautious that we impugn the reputation of PAs by citing those kinds of events that don't have to do with independence, from that, at least the independence aspect. Secondly, I think we need to keep in mind whether we want to introduce we should be careful not to deviate from our principles-based approach for the code. And one of my concerns is that there seems to be some view that around materiality maybe being part of the issue. And I think we have to be careful. Presumably, and in the past, the board has concluded that materiality was a relevant factor, as has the other big framework we talked about, the SEC, because it reflects that the fact that the threats to the conceptual framework and to independence either, I don't know what the right word is, didn't exist, were low, or were at an acceptable level. And I'm a little cautious to throw out the concept of materiality and then have to explain why we apply it for other entities, but we're not going to apply it here. And then I think I would reiterate the point that that when you look at third parties, the vast majority of those third parties do not influence the performance of the fund. The custodians, the transfer agents, the record keepers. And so, and that I think is recognized when we talked about the prong in the ICC, that they were only included if they were under common control. And I think that fits with comments that several other board members made about, is it all sort of in the group? And there are situations where you do have somebody who goes out and establishes the fund, gets an independent directors, is the advisor or manager, and they may do that a lot. And that may be a point that we want to focus on. But I think the focus needs to come around to only those activities or decisions that significantly impact the performance, which tends to be the advisor's role in terms of buying and selling interests. And, you know, even there, we have to think about how to deal with the fact that technically the board of directors or board of trustees, in almost all the cases I've seen, have the ability to terminate the advisor and hire somebody else. But yet I do agree that by contract, there can be places where the advisor or / manager is really impacting the performance, the significant performance of the fund. And then I guess my my last point is that we need to be careful. The code today, this goes back to the principles approach, does in fact include prongs that deal with control and material significant influence. And if you are applying those under the code properly, then perhaps there isn't that gap. I think where maybe the gap is far narrower than what got articulated in my personal view, and that it probably relates to who is the primary party making the investment decisions that drive the performance, and should that entity be within the purview of whether there should be independence. At the same time, we need to think about the fact that some of these advisors and managers can be advising more than 100 funds. And that can drive a marketplace reality that they might not be able to find. Everybody might have to be independent of them in terms of what they need for other activities to support the ongoing development of their business. And so I think that there's a lot more work that needs done here. I'm not sure we have the gap fully defined. And I think that's consistent with comments like Amarjeet and Andy and Lori and a couple others. So I'll pause there, but thank you.
Thank you, Rich. I see a few people wanting to speak. Maybe I had some comments at this stage, but I'll let Mark, some of you speak at least.
Thank you, and you know, so thank you for certainly a very interesting and challenging discussion. I suppose, sort of listening to it, where I get to is that there's potentially something of interest in there, but we need to do further digging to determine whether or not there genuinely is a ground for activity. I suppose one of the things that strikes me is when you started the presentation, you said that there is potentially a narrow gap in the code. But I do worry about whether we understand the impact of the narrow gap, and that is all of the things that you've said about CIVs and all the things that you said about funds could equally resonate in alternative assets and private capital. And if that is the case, are we comfortable that we're not at risk of creating a tailor-made solution for a narrow problem that in fact resonates much more widely over different parts of the market? And certainly I'd be really interested to understand that if you develop this proposal further, where else does it impact on, and what are the other consequences there? Because it might be to address a very particular circumstance of that link that we've heard about, but I wonder whether we know what the true sort of impact of it would be if we ever got to the stage of reflecting something in the code.
Well, maybe before we proceed with questions and comments, I think that I feel that to say one or two things. First, with respect to why are we doing this project, and it seems to me that we are a little bit going in circles, because I think it's the third time here that we discuss why we are discussing this project, and there is a reason. I mean, we may like it or not like it, but the reason is that because the IESBA has a commitment, public long-time commitment, to go back to this topic and see if there was any need to tweak the code or include anything in the code to address specific problems or gaps related to investment funds. We haven't said yet that we are going to do it. That's exactly what the working group has been requested to do, and I think it's what they are presenting us, is the work and research and analysis and reflection about what's the reality, what's the code says, and if there is anything that we should do in that respect. So this is the context of this working group. This was discussed when we decided to create a working group, and this is in the terms of reference, and it responds to a request from stakeholders, concretely from the PIOB a long time ago. But something that the board decided that it was necessary to do. So this is the why we are doing this. And secondly, irrespective of all not responding to any of the comments made, which for me are very valuable, I think that the group is not yet making a proposal. So I heard here proposals. The group is not yet making a proposal, so far, at least in this presentation. The group is asking us if we think and we agree that there is a gap, which of course will be the basis for any proposal that the group may want to work on and bring to the board. So I think that we are going probably a little bit too fast in drawing conclusions about, no, that let's not move, let's stop, and etc., because we are not yet there. That we don't have a proposal for action. We have a question to the board. Is there a gap, and is there any need for this group and the board to address that gap and see if there is anything that we should do in that respect? So, and thirdly, I think that I said that the last time that we discussed this in June, but I think it's probably important to recall that I'm not saying that there are, I mean, there were some comments and valuable comments around well, we haven't seen any scandal which was due to the auditors' lack of independence. Maybe this is the reality. But I think this is that investment funds are important enough in today's capital markets for us to make sure that, as Amarjit said, we don't wait for anything to happen to get the conviction that it's necessary to act. And I'm not saying that we need to act. I'm just saying that it is important that this board takes this topic seriously and comes out with a conclusion about yes, no, let's take action, let's not take action, because investment funds or CIVs today account for an incredible part of capital markets. In many important jurisdictions and markets, and I could name a few, they are much more important and relevant than listed companies. Just thinking about two important European markets like Luxembourg and Ireland, what's listed companies there? It's nothing. It's about investment funds. They involve a lot of retail investment, individuals, people who put their savings in these instruments. So there is, from the economic and market perspective, they are important, and whatever is the conclusion, and myself, I don't have any conclusion so far. I would just like the board to be sensitive to the need to look at this carefully, and if whatever conclusion we will make, not now, I'm sure, but in the future, that this work, this very valuable work, by the way, is taken into consideration, and that whatever we decide takes all these considerations on board. So sorry for this, but I hear again, we heard it in June. Why are we doing this? And now somehow I'm hearing it again. So I think it's important that we know why we are doing this and what's the objective of this work. I still see a few people. I don't know, John, did you want to speak or? Okay. Paul.
Okay, thank you. I think definitely not questioning whether there is a scale value proposition when you look at the CIB and the fund space. There's definitely a scale risk that needs to be managed there. I think the question that's being asked is it the quality and reliability of the audit process, or is it the effective oversight of the fund management practices that's going to address this? I think that's where we're going back and forth on, and it's if we are really trying to give firm direction on how we can improve the ethics, practices, and independence of the preparers, the assurers of the financial review. But the question is it that is the thing causing the holes, that causes the problems, or is it adequate, effective regulation and oversight of the fund managers, pension practices, and decision making? I think that's where we're getting stuck.
I think you have a point, Paul, which will be very valuable when we get to discuss what to do with this, because we may well come to the conclusion that it's not about changing the code, but about issuing, for instance, a staff alert, recalling what the code already has, and touching on that important topic of supervision and oversight. David.
Thank you, Chair. I think one of the couple of comments, perhaps, maybe building on what some others have said. Personally, I quite like this project because I agree there is a risk to the public interest, and that's why we're all here at the end of the day. So I support that very much in terms of the direction. There are a couple of things I think about. One is to the point that Paul just made, and maybe this is, again, a bit preemptive, but given the direction of travel for us as a board, which is to expand the code beyond just the profession as well, it might be interesting to look at this particular issue just with a wider lens. Not that we're changing the code more widely at the moment, but that might be an interesting point to what Paul just talked on around where does the failure sit. I think when it comes to, certainly in my experience, when it comes to challenges within the profession, they're not always obvious and they don't always come to light either. So I think even if it's not in the public domain, that doesn't mean it hasn't happened. In reality, it could just be framed a different way. So I think it's important that we keep that in mind and we don't look just for media examples to say, well, okay, so see, we have it. And then I would say just a final point I'd like to make, if you'll bear with me, is that when we talk about conceptual framework, if we only rely on the conceptual framework, then I'm not sure there's a whole lot of work to do, because other standard setters have a conceptual framework, but there are still issues. So I think the reality is when we think about this, we need to make sure that we don't get caught in the conceptual framework as the answer, that we need to think more broadly. And I think it's to your point, Gabriella, there are many ways to solve, and it may not be the code change itself, but that doesn't mean that there aren't other ways that we can show application and remind people that, yes, here's how the conceptual framework would capture that, if that in fact is the case. Thank you.
Thank you very much, David. Amarjit?
Quick reaction to David's point. I think we should be mindful of our domain, and we should draw a line. In the sense, what I'm trying to say, we should not get into the diagnosis of supervisory failures, regulatory failures, or the investment management related issues. Our focus is ethics code, and if there are any gaps, we should fix that. Otherwise, we would run the risk of digressing into other issues which are not in our domains.
Okay, thank you. Ken?
Thank you very much, Chair. Just a few observations from my side. I suppose, like you, Chair, I have heard this same discussion probably the third time, and the same comments. And clearly, there are a number of questions and a level of uncertainty as to what exactly is the problem. And I'll probably start first with, before we go even any further as to what exactly this project team might want to do, start with this question of what is the gap? Because we've heard this question already repeated a number of times around the table. And to my mind, for this work stream to proceed, essentially it has to have something to do. It has to have a problem to fix. So what is the gap? And that, I believe, should be the first order of the day to address. Because if there is no gap, we cannot pack our bags and go home. And from there, I then have a follow-on question. Is the gap a matter of clarification in the code as opposed to something that's simply a gap or a hole in the code that needs to be filled? Because if there is a view that some of the provisions in the code could potentially address some of the questions we're looking at. For example, for those third parties that have a level of influence over the, let's say, the performance of the fund, or how the investments are being reported and accounted for, are these third parties essentially parties that have control or significant influence over the vehicle? So to my mind, we need to answer this question. Is the gap a matter of clarification, or is it truly a gap that needs to be filled? Perhaps, as some might even argue, is suggested by the approach that the one regulator has taken in the US here, in the the USSC, as John has walked the board through. The USSC has developed its own expanded definition of well, whether it's expanded or not, but it has a definition that scopes in investment company complexes, and it has a various sort of categories and so forth. So I think I would start first with this question and really have the board answer this, weigh in and consider all the different aspects or dimensions of this question. What is the gap? Is it a matter of clarification? Secondly, I would then address the cost benefit question that Laurie raised earlier. And I would connect that to what Gabriella spoke about in context, which is that we are really looking at a vast market of investments of the Joes and Marys in the streets and all their life savings and pensions, etc. And therefore, the cost benefit analysis has to be made in the context of an analysis of the public interest. And that has to be very clearly articulated. Thirdly, in relation to independence, which is really what is at stake here, it's not about the performance of the audit, it's not about anything else, but it's about, does the code sufficiently substantively address the independence questions. And there I would really draw out that when you think about independence, it's not really about what is the actual issue, but because independence is also a matter of perception. It is fundamentally the definition of independence. And there I would perhaps challenge the project team to go and really talk to the investors, present to the investors perhaps certain scenarios or certain problem statements and ask the investors what their views are if they are asked to weigh in on independence. And not so much, as I say, on whether there's actual independence or not, but whether they would perceive that there is potentially some questions on as they would see the problem statement. Fourthly, the matter of focus is important, absolutely. It shouldn't simply be a matter of revising the definition of the related entity, if indeed that is called for, because the board will have to be very careful as to where this will take the code in terms of the application of that definition, if it is to be revised or clarified or updated in whatever form as might be determined. And finally, I would ask, and maybe it's more a question as to whether the project team has actually spoken to the staff of the SEC or even other jurisdictions that have regulators, and whether you've had a bit of the context and the work that they've gone through in looking at the sort of the questions in this area.
Yes, we have. That was set out in the paper, Ken, around the SEC, and that was all based on discussions with them. Yeah. Thank you.
Thank you, Ken. I'll just go back to your suggestion that the team speaks with investors, but the CIVs are the investors themselves. So we are here in circles, and this brings me to something that I wanted to say, but I forgot, which is obvious, and I don't need it to say, but these are the big investors that move the needle. I mean, speaking about, I don't know, CalPERS, the California Pension Fund, they decide the life of listed companies. If they decide to sell or if they decide to buy, the listed companies are sometimes completely in their hands. They decide the life or the death of listed companies and sometimes of the market. So I think that we need to have this in mind. There are very small entities which do not move anything but their families and their houses, as there are other ones which are actually the pillars of the market and the pillars of some listed entities. So they are not irrelevant, on the contrary. And so I think that the problem that speak with investors, but they are the investors. So it's difficult to have a perception about what are the perceptions about the role of the auditor. And what I want to say is that the group has a difficult job here. It's a different animal. It's a different reality. As Paul was saying, the eyes of regulators and etc. are very much away from this problem. So they don't have an easy life. But I think that we are making progress. What you presented today, I think, is very far away from what you presented in June, and it's a great job. It's much more clear. It's much more. It's much deeper, and etc. So. I think that Ken's guidance is very useful. I'll be curious about the conversations with investors, but that's always our question, because speaking with investors is difficult.
Can I just add to what you're saying? So the management company or the investment advisor is the one that's making those decisions for that investor, the CIV. They're the ones that are making the data decisions about what to invest in, who to invest in, how much, all that sort of stuff. So they do have a huge role in the fund itself and the influence in the fund. So when we talk about materiality and control, that's looking from downwards and whether that entity is material to that one. But if you look at it from the other perspective, that manager is really material to the fund in terms of what it's doing for the fund and the decisions that it's making for the fund. So it's a different way of looking at it, but it is actually a very important thing to consider.
I think it's important to emphasize that I think today we were trying to make sure that people understood the thought process that we had been developing. We're not trying to say X or Y or Z is the solution, or even to necessarily express a view about the breadth of the issue, which is Ken just touched on, and actually David touched on, I think. After the previous discussions, the objective was to make sure people understood what we were looking at, what the issue was that we were looking at, and how that might relate to the code. John has just made it, in my eyes, as he knows, a point that I attach quite a lot of importance to, and that is that conceptually, the definition of related parties looks at whether or not the entity above, whether the entity below is of material or to the entity above. What it does not do is look at whether the entity above is relevant and influences the entity below. It's entirely looking at it from the perspective of the top entity. Now, as a result, in the situation we're now dealing with or considering, we're talking about something outside the entity, the audit entity, who's influencing the audit entity. And that isn't at the moment a concept which is necessarily reflected clearly in the code, or at least, let me put it another way, we need to be satisfied that it's adequately represented in the code. And in that context, it's also relevant to look at what the practices of firms when they are assessing the independence of their own independence in relation to entities affecting the audited entity. I don't want to go too far on that at the moment, but that seems to me to be a window into the extent to which this is an issue or not, because if the firms are looking at it and they have a structure for looking at it, that's obviously a big tick in the box. If they don't, then that raises a question about the extent to which we need to deal with it. So, but please do not assume that because we say we think we've identified a gap, that means the answer is X or Y, or it's got to be done. We're trying to make sure you understand what we're going to be working on going forward and the issues that we're trying to actually then develop and bring back to you as being the reasons, exactly as Gabriella and Ken, you have articulated, that justify or don't justify a course of action.
Okay, thank you. I think that we actually so far, but we still have a few slides.
Yeah, we are running a bit behind, but I'll sort of move through the next bit a bit quicker than was anticipated, and we'll get across to John for the last bit in terms of where we want to move forward. So yeah, the next few slides is around the operational structure and management. We have talked about this a little bit, but there was just a few things we wanted to point out. So yeah, obviously, as we've mentioned, we've seen corporate structures, unit trust, contractual. From the corporate, there's a board of trustees or there's a trustee. In terms of the governance, unit trusts, there'll be trustees, but there's also these contractual based where sometimes there might be an external trustee or a board, but there's also instances where there's actually the management company actually assumes that governance role as well as the managerial aspects. But invariably, what we see, there is no employees in the fund. So there's generally no one within the fund to undertake that management. So these functions, so the day-to-day management, managing investments, controlling assets, they're all undertaken by an external third party or parties. They're generally operating, the third parties generally operating in accordance with underlying foundational document. There might be contract like Rich has talked about. There might be specifics in the laws and regulations around what they need to do. And that generally includes those fiduciary duties, the best interest duties, those sorts of things that we've been talking about. Sometimes they'll delegate certain functions. So for example, in Europe, there's a management company, but it can delegate sort of functions to an investment advisor and also to an administrative type, an entity that undertakes administrative type functions. But often there's really that main sort of third party who remains responsible, even though they've delegated, they might remain responsible for those functions that they've delegated out. So this here is trying to sort of depict as an analogy that usually the inner mechanisms of an organisation, or in other words, the mind or brain of the organisation, which is responsible for the day-to-day functioning or operation of an organisation, that's sort of deconstructed and it's performed outside of the body of the investment So yeah, with investment schemes, the management, and in some cases, like I mentioned, sometimes there's governance. It's actually performed outside of the scheme itself. Just thought it might be useful to just bring, these are some of the questions that we asked respondents. So I just wanted to bring forward some of those sort of points that people have responded to in the questionnaires and through the interview process. So this question asked about who has oversight and who is responsible for governance of the scheme. So again, yeah, responses varied, and again, it depends on the facts and circumstances and the type of fund structure, and also the jurisdiction and the rules and regulations. So this just summarises some of the responses. So the first bullet relates to a corporate scheme where the scheme itself has its own board and it enters into an agreement with a management company that acts according to that agreement and subject to fiduciary obligations. The second bullet is also a corporate scheme and the board is responsible for governance and oversight. The third is more a contractual fund. And in this example, the board of the management company is the ultimate decision maker. In other words, the scheme itself doesn't have its own governance function. The fourth bullet is a unit trust for a scheme where the trustee or the trustee of the trust holds the assets of trust for the investors and then appoints a management company to manage the fund under an agreement. The fourth and last one's also from a trust example. And then moving on to the question we asked around the management company. So this asked what was the role of the investment advisor, the managers or the management companies. Again, responses vary. However, a common response is that the third party manages the day-to-day activities of the operations of the fund. The second bullet point there expands that to the implementation of the investment policy, administrative duties and managing assets. The third one also refers to managing compliance with regulatory requirements. Again, this is the management company doing this. And the final bullet mentions day-to-day management of the fund, and again, under the oversight of a board. And as we've sort of mentioned, there is a bunch of other roles that are involved with these. So there might be sponsors, custodians, transfer agents, administration. Sponsors can be quite influential to both the creation and continuing operation of a scheme. So they might set up the scheme, set up founding documents, and ensure that the schemes meet legal requirements. And then custodians are generally responsible for safeguarding scheme assets, but in some instances they actually have more influence in aspects that relate to sort of the management side of things. So this is really just to sort of demonstrate that there is a spectrum of CIVs that we've seen. So you've on the left, you've got the corporate, in the middle, you've got your unit trust type arrangement, and then there's the contractual thing. So there's sort of a range around there in terms of the level of governance, I guess, that relates to the scheme or within the scheme, and also that it does vary. It varies facts and circumstances across jurisdictions, but even within jurisdictions in terms of the structural types, and also around the jurisdictional differences that we've seen, whether third parties are considered to control or therefore part of the audit client. But often that's because it's not because of what the code is saying. It's often because there's, like I mentioned earlier, it's because the jurisdiction has put in place something specific in terms of their laws or regulations to incorporate that or create that, or sorry, determine that there is control or that it is part of the audit client. And this is really just wrapping up what we've talked about anyway, that the fact that if it is a related entity under the code, the status, whether it's a PT or not, that will determine who is a related party and who's part of the audit client. If it's not related, as we've mentioned, then it's not part of the audit client, irrespective of whether it's a PTE or not, and that Part 4A does not directly apply. And then, yeah, the issue we're trying to capture is whether it performs significant CIV activities, whether it's a decision maker, maybe more on the day-to-day activity side of things that we've been talking about, whether it's operating the scheme, and whether that creates a risk around the independence provisions not being adequately assessed. So the last slide here is what we're talking about here is not around the audit performance, that sort of thing, but these are the sort of activities that we are seeing these management companies, investment advisors undertaking. So it might be setting policies. It can be around authorizing transactions. Often they're controlling bank accounts or investments, making decisions around or taking responsibility for the fair presentation of financial statements. There's certain aspects and those things vary in terms of the level that they are. So the question we wanted to ask the board is based on those with looking at those types of activities, is whether the board believes those are relevant in assessing whether an unrelated third party should be part of the independence assessment, or whether you think there might be other factors that should be considered. So it's just whether you think those are relevant aspects in terms of us assessing whether an entity might have, significant influence on the operations, the performance, the risks and rewards of the fund, or whether there are other aspects that we should be considering as part of that. So I'll just go back to the list. So whether the board thinks those aspects are important, or some are important than others, or.
Thank you, John. Vanya.
John, that is definitely not my campus of expertise, but I was wondering during the first round of discussion here that maybe we failed to find a problem so far, exactly because pension fund complex investments are highly regulated in each jurisdiction. Maybe the gap that we have right now in the code is being supplied by different regulators in each jurisdiction, which is fine. The problem is that it's fragmented. And so we have a problem that is global, and we might have a specific investor that will be doing investments in a different jurisdiction, does not know exactly what the regulation is, and they will be unprepared to deal with the problem in the future. So if that is the case, I think that is one of the main reasons for IESBA, if this gap is a reality, for IESBA to take care of that, because we want a global solution that can be used everywhere for dealing with that. And so, and what you just said just confirmed my perception. If I'm wrong, just disconsider, because that's not my specialty.
Thank you, Vanya. Mark.
So on your list, I think I'm a bit like Vanya. I don't know whether or not, but presumably next time you come back, you'll be able to tell us whether or not these are the right things with your further sort of engagement. So, it appears perfectly reasonable. I think I think it forms, a good basis for further work. And I don't necessarily know the answer to it, but I'm sure you'll be able to tell us next time round on the basis of further engagement with some of the third parties.
Thanks, Mark. So I guess the other point was we're saying these are the things we're saying that they're doing, not all of them necessarily, but then it's a different aspect. But I guess the question is, whether there's other things we need to consider in terms of a management aspect, or day-to-day control, or however you want to put it. So thanks, Mark.
I do think possibly in that respect, and it also picks up on Vanya's comment about, the sector being a regulated one. You might actually also think about whether or not these third parties are actually leading the engagement with the regulator, because that might also have a bearing.
Thank you, Mark. I would say from the knowledge that I have from the past, from this reality, that these realities, CIVs, are highly regulated, but as financial instruments and structures, not exactly with respect to the auditor. The financial regulation relies on the audit regulation to do what they have to do. So they say the auditor has to come in, the auditor has to say, the auditor has to do, but they don't care. And most of the times they don't oversee, and they don't even have the authority to oversee the role of the auditor. And that is can be part also of the problem. So I think that besides that, maybe speaking with some regulators and some regulators of the entity to see their perceptions about what can be happening on the other side might be also helpful. Chana, please.
So a couple of points. I think this, as Mark said, this is a good basis to start having a look at it. And even if, you know, they're not really management, if they're doing these kind of things, then they're in effect, they're undertaking management responsibilities. Another thing that occurred to me is these investment managers may be managing a lot of funds, so they may need an auditor to audit those funds, and whether, because they are not really captured, whether there's some sort of a referral thing going on, like where they are sort of, you know, if you have a good relationship with the auditor, that particular investment manager, whether they are giving a lot of audits to that particular auditor. So that might be something you might want to look out when you're doing your research.
Thank you, Chana. David, please.
Thank you. One of the things I was thinking about when I was reading this list, and it dawned on me because I've seen a lot of organizations outsource significant activities to third parties. And sometimes the way that we word things can infer very, very different things. So for example, if you say controlling a bank account, that's a very different thing to me than managing transactions for a bank account. So I think when we go through this, it would be helpful to differentiate between true controlling decisions versus managing as an outsourcer-like responsibility, because I think that will help crystallize a little bit more what we mean by to what extent are they actually controlling versus to what extent are they being told what to do and they're executing within the mandate.
Just on that, some of the things we've been considering is around whether they've got significant impact on the performance of the fund, for example, or the risks and rewards of the fund, those sort of things, whether they're doing things that actually have a big impact on the actual performance and therefore the resultant impact on investors, if that makes sense.
It completely does. So I think looking at it more from a P&L impact loosely, I think is perhaps a good place to start and then work backwards. But yeah, performance, exactly.
Thank you, David. John, Rich, please.
Yes, thank you, Gabrielle. I'd build off of what David said and John, actually your response, and it goes back to the question on the gap, because if you read at the end of the gap question that you asked us about, the focus was on investment advisors, managers, and sponsors. And I'm not as convinced that this section of 400 is the right list. It has some elements that might be applicable. But remember, this was developed as to the kinds of things that a auditor might be providing in the form of other professional services. And David makes a very relevant point about the outsourcing. But I think, John, you astutely mentioned, you know, what are the things that really impact? And I think when you look at that, it's the aspects of this and any other things we want to put together, which is what are those decisions that drive the performance of the fund and the success of the fund economically? And so I think that aspect of this, you're on the right track. And I might suggest that the project team might want to look at the discussions both in IFRS and in the FASB literature around powers that are part of the determination of control, because I do think that gets to the point of those kinds of powers over the decisions and activities that drive the economic performance of the entity, not necessarily whether the custodian has the proper dual control in place and things like that. And I'm not trying to pick on that. I think there's a higher level thing that you've astutely hit on with your gap question about those three entities. And I think that's where you might want to, you could focus on what are those decisions that really drive performance. So thanks.
Thank you, Rich. Andy, please.
And I think I'll just add on to those comments. I think you were circling around the area in terms of the decisions and the management aspect. And I'd ask to consider some sort of like combination of factors or materiality of the factors. I don't think there'd be necessarily a one yes would do it. And when it comes down to the significant influence on a company's profitability, I think it means because of the decision making. I mean, I could hire a trucking company to deliver goods to my customers, and they could screw up the delivery, and I could go out of business. That's not the type of thing you're talking about. You're talking about decision making and authority and management. So, I mean, I think this is the list with materiality and in combination would be great.
Thank you, Andy. Rania, please.
Thank you. So, I mean, when I look at this list, and again, very much in line with what's being said around the table, perhaps we should be, I mean, in order to assess the management, I mean, the level of management or decision-making responsibility or power, perhaps we should be looking at it from the flip side, in the sense that what is the impact on the investment advisor of making the wrong decisions. I think that is perhaps because then if the auditor, let's say, identifies any, let's say they are dissatisfied with the performance, and they make that, I mean, they pick this up, then I think the issue is what is going to be the impact on the decision makers, or in this case, the investment advisors. And so as such, how will the auditor's opinion impact them? And this is when I think there might be an issue. That's my point.
Thank you, Rania. Sadia.
So just a reminder that this list wouldn't include things that are strictly prohibited for an auditor. So things like custody of client assets and those type of items that you might want to bring on, because it wouldn't be strictly prohibited for those type of entities. There's a paragraph, and I can't find it right now, but on this year, when it comes to management responsibilities for auditors, it does say that you need to take responsibility, understand the matters. And I think that's an important paragraph to draw out some practical aspects to understand whether this entity is actually taking on management responsibilities.
Please.
Yeah, thank you. And I echo most of the comments that already have been put forward. In addition, so I will not repeat the same. In addition to that, probably it is worth for the working group to start thinking also about, say, in a different way, not starting really, when trying to identify a relationship between these third party, probably the starting point is not the code, because the code is defined for other purposes. And maybe the starting point may be to identify who is the power, as already has been mentioned, how oversight is defined in some of the jurisdiction you have examined, how significant influence is defined in the same jurisdiction, whether the local regulation identify, or let's say, started from any of these concepts in order to build particular regulations. Because if you consider the local regulation, you may find different solution, of course, different implementation, but common root cause why these regulations have been implemented. I have in mind a couple of examples whereby the solution were completely different, but the starting point was really the governance, the oversight, and the power to define, direct, and basically determine the outcomes of these collective investment vehicles. So I think that probably you need to consider broader concept in order to try to identify the relationship. Because if you stay just on the code, you will, let's say, inevitably have the limitation of all the concepts that there are there, because they are only limited to auditor independence.
Thank you, Luigi. Tomoyo, please.
Thank you, Chair. First of all, we are trying to identify related entities. So starting from saying unrelated third party, I think is a bit misleading because at the end of the day, we are trying to identify related entities. So it's just a matter of wording. The other is just want to agree to Rich's comment that maybe thinking about starting from the power might be a good idea. The power definition in the IFRS 10 in the last part of June meeting, these three are probably one of the key elements to determine related entities. So I think thinking about power is a good idea. Thank you.
Thank you, Tomoyo. Luigi, do you want to come back on it? Okay, so you still have a few slides, but I think they are more to present the work that you have done in terms of outreach and. Yeah. Okay, because I was going to ask Janine, but we can finish the presentation because you may have. Oh, do you want to come in now?
Yeah, I can.
Okay.
There's one thing that is all the time in my head, and that is, do we also, or do you have also looked into how the audit firms treat all of this currently in practice? Because we can look at this from a theoretical point of view, focusing on the code and how that there is a gap. Because in my mind, I also think about trust companies and the like, and these management roles, they can differ from, depending on the setting and the agreements made. The auditor, in my thinking, is taking them as if they are the management, sort of. Sometimes also, I think it's also important to understand who is really appointing the auditor in this setting. Formally, it can be the board, so to say, but in practice, it can maybe be the fund manager. There are also those kind of practical things to get a better understanding of the whole picture and what the risks are actually that you want to address. Or maybe you see other things than only focusing on the gap from when you only start thinking from the code. But you see maybe more issues if you also look at how is this working currently. Audit firms, they have all kind of procedures. What are they actually doing and how do they treat these kind of structures? Thank you.
Thank you, Janine.
Yeah, quick response. We have met with a number of audit firms in relation to this, more at the top end. We want to sort of go down a little bit as well in terms to the lower, bit smaller, medium-sized firms as well to get a bit more information on that. But yeah, thank you for your points, and we'll take this.
Thank you. So going on to the last question is around stakeholder engagement and what the project team is proposing the way forward. So this just kind of setting up the question. The question was in the paper. So in the appendix, there was a list of the stakeholders that we've engaged with. There's also who those stakeholders were. And like I mentioned in the beginning, some of them were firms, but some that's actually the industry regulators that we engaged with, and some we haven't engaged with investors, but it's a wide variety as well that we have spoken to. The two that's marked in asterisks is that we've received questionnaires or we're in the process of receiving questionnaires, but we haven't conducted the interviews as yet. So that's why they're highlighted in the asterisks as well. So this is the slide that John alluded to previously. So we've engaged with 17 jurisdictions to date. The two boxes, the orange and the green one, you would see is a repeat one actually was included in the June papers on the size of the market and just to give the public interest and why it is so important. But I actually delved a little bit deeper into the report and determined from the jurisdictions that we've actually surveyed and questioned and interviewed represented 75% of the total regulated open-end funds represented in this graph. The two that asterisk is not included in here. If I do include them, we get to 80%. Is that enough? No. So it's just showing that we've engaged with the vast variety of jurisdictions to get a big picture. We've heard about Luxembourg and Ireland. We've engaged with them. We've actually had 2 discussions with specifically, and I think we'll probably end up discussing further because of the significance in the European environment as well. So this is just to kind of get the landscape, what we've done so far.
Sorry, can I just interject one
Yes,
second?
you can.
But also just to note, this is representing like mutual funds as well. And as we were talking about earlier, there are different sorts of funds as well that we want to sort of delve into too.
Perfect. I just want to get my notes in front of me as well so that I don't miss anything. So the question that the purpose why we are proposing and further stakeholder engagement, and we listed as an example a discussion paper and a consultation paper. And the reasons for that is, and I think we touched a lot about it that currently in the discussion as well, is to understand how the IESBA code is applied to those involved in both collective investment vehicles as pension funds and how the auditor independence is evaluated. To the point, how the auditors are practically doing this. We didn't just engage with firms. We need to understand how they're evaluating it, how they're doing it practically, how the smaller practices and the medium practices are also looking, especially if we start moving to the pension fund side as well, because there are differences in sizes. So really looking at that as well. And then the second one is to identify circumstances where the code might not adequately provide the auditors to assess their independence from those responsible for the operation and the performance of the scheme. We're also looking at whether also the code should be enhanced, how big is the gap, how narrow is the gap, is there a gap as is perceived out there, the perceived independence requirements, we mentioned that as well. So really get to that point as well. And we are looking at practices and firms that we want to engage with, but regulators and standard setters and others as well through the consultation process so that it supplements the desktop research that we've done as well as the interviews and the questionnaires. We will have to be very sharp on what we are saying to Amajit's point exactly to what we want to ask and to identify exactly where we need to go. So that is where we want to kind of lead into the question is, do the board support us in engaging more broadly like with other stakeholders, for example, through the issuance of a consultation paper, and that can be the next step.
Thank you very much, Jean. So board members, do you have any questions, additional suggestions to the group about how to proceed further? Are you happy with this approach, with the outreach undertaken? Okay, thank you very much. I think this was a very lively discussion. I don't know if you want to conclude, wrap up, tell us anything else?
No, nothing else said, I don't think. No. Thank you for all your input and.
So on my side, my congratulations to the group. As I said, I think that you progressed immensely since last June. And if I can remember, last June you already had some proposals to test with the board. The board said, no, it's too early for proposals. So you got back and now you are bringing the possible reason to make any proposals. So I think it's a good direction, but the presentation was extremely clear. I think that you made, as we can see, an incredible job in terms of outreach, not only in terms of regions, but in terms of background of stakeholders. And I think that this is going in the right direction. I hope that you feel that you have the necessary direction from the board about how to proceed. and I'm sure that you'll do it rightly. And I keep on thinking that this is an important project, whatever the conclusion will be. And personally, and I think we all are at this stage very open to any conclusion that may arise. What we couldn't do was not to address this topic and leave any space for doubts or concerns that there might be something that we might have to do and we have not done. We are not yet there, so I'm happy, and I'm happy with this discussion because we are all very focused on sustainability for the reasons that we know, but the board is still very much alive, and at the end of a day, which was already very, very tiring, I think that it was excellent to have all this level of involvement and with very different comments and suggestions, which again, and I will never stop saying this, shows the importance and the richness of having a diverse board around the table. So this is just helping us moving in the right direction. And I'm going to stop here because you are all anxious for the dinner. So I'm going to pass to Ken, who will speak about happy things.
Yeah, I will speak about happy things certainly, but just to close off CIVs. I know you've heard enough about CIVs, but from my perspective, this has been an extremely rich discussion, and really all board members have really weighed in on this and really given the project team amazing feedback, and it's going to be a lot of work. I think you're going to have quite a bit of a challenge digesting all of it. But I'm just looking ahead as to how the project team is going to proceed from here on, because the charge to the work project team has been essentially to come up with a report with some recommendations to the board. And I think there is going to be a need, maybe we don't need to come to an answer as to where we land on the final report. But if there is an idea of a consultation paper, we're going to need to work out how the consultation paper is going to dovetail into this report with any recommendations. It may be that eventually, once consultation paper has been done, whether it's the consultation paper or discussion paper is with initial semantics, and we can work that out. But maybe it's a sequencing question I'm raising, which is whether the project team undertakes the development of a consultation paper first and bring that to the board, of course, in due course, for the board to review that draft consultation paper and provide all the relevant feedback. And then for the project team to go out and engage with stakeholders in that consultation paper, and eventually come back to the board with basically the full analysis on all the questions that would be raised in the consultation paper, and then develop the final report with the recommendations.
I think that's the only sensible way of doing it. Otherwise, the reality is that the report will be saying, this is what we think we need to do. And I think can be more constructive in actually working out developing the consultation paper, making sure that we've got the groundwork done for the questions that then get asked more broadly, and everybody around the table has an opportunity to follow the logic of the document and the rationale for it, rather than wanting to say, well, why? Well, why? Because the report will not have got that far. So I'm, if you'll forgive me for saying so, I'm quite clear that the right course is to develop a consultation paper and give the board an opportunity to critique it and make sure that we've covered all the ground that needs to be covered.
Just before Ken speaks about the dinner, 2 notes from my side. On the one note, to congratulate the project team for the way you are able to keep your faces with the incredible amount of work that each time you come to the board, you bring back. So I was observing you, but there was no expression of fear, anger, or exhaustion. So congratulations. The second one is to the board, and this is anticipating what's going to happen in December. I'm afraid that this project is falling into a time of this board where we are all crazy about a lot of things and pressured by a lot of things. So there is a risk, and I think that this constant question about why are we doing this? I got surprised in June, but I understand that well, the circumstances are what they are. December is going to be a very, very, very special moment for this board with well, other important things happening, but I'd ask you to keep as much as possible focused, because whatever we are going to do, it's going to be the decision of this board. So, and even if it's not evident for everybody that this is important, I believe that it's important to get it right and to make a collective decision of this board about are we going to do, aren't we going to do, what are we going to do? So, I mean, from here to December, everybody will forget this, but for the records, I said it, and maybe I will recall you a bit before the board. And
Yes, so just a few announcements. Then we have a board dinner. It's scheduled for 18:45, so 6:45. For those who will be going to the dinner, the ask is that you meet in the lobby of the Hilton Hotel at 6:30 p.m. If you will make your own way directly to the restaurants, if you could let us know so that we can make sure that we're not leaving anybody behind. Thirdly, if you have not made your contribution for the dinner, if you could do that as well, that will help a lot. And finally, or maybe two final things. One is you should all have received a printed copy of the handbook, the 2024 handbook. If you would like additional copies, not too many, but if you would like an additional copy, let us know as well, and we will try to do our best. 10.
For me, first of all, just recall.
Okay. All right, Astu has a task already cut out. And finally, do not forget to clean up after yourself, please. Thank you. So we will see you at the Hilton at 6:30.
I'll try.